Madam, this is a matter relates to the compulsory retirement of a judge family court at 55 and pleadings are complete. I pray for listing of this purpose.
May I please, my lord? Item number 33, it is the income tax matter. Now assigned to court number, honorable court number 1, my lord. Just verify and you can go to the assigned item.
The present petition has been prepared for the challenging of non-payment of sitting allowances of member of JJB Jajpur. The case has been listed on 5/9/2024. The Honorable Court direct to list this matter on 30/9/2024. But it could not.
My lord, case W, my lord, challenging the judgment against the single bench order, my lord, 2018 matter, my lord. And another matter is, my lord, appellant are juvenile and one appellant more than 10 years in custody, my lord.
My lord, it's a land acquisition matter, old matter. Admission, old matter.
My lord, this is a matter 2019, my lord, against the order of the SAT. In the meantime, the petitioner challenged the order of the tribunal in which I was the applicant for the, and in the meantime, he has been retired. Because of the pendency of this case, I'm unable to get the benefits. So I pray, my lord, both the matters.
My lord, fresh admission, my lord, enhancement of our.
No, appeal, my lord. What is it? 12 years in jail or 9 years of custody?
What
12 years or 9 years?
Weekly list, item number 1.
Yes, my lord. My lord, in this case, my lord directed me.
Please use the mic properly.
My lord, in this case, my lord directed me to file affidavit. Because kindly file affidavit.
Which order we directed?
My lord, page 55. Relevant order is page 55. Since there was rejection, my representation was rejected without any reason.
You took time
yes, my lord.
To file some documents along with the affidavit.
There is no document has been communicated to me by the district judge. No document. My lord,
what do you want now?
My lord, kindly go through the page number 55. My lord?
Yes.
My lord, that representation was rejected without giving any reason. On that day, my lord, yes.
Page 55.
Page 55, my lord. The representation was rejected without giving any reason. So, my lord thought that there must be some reason by the district judge, by the recruitment committee. So, that has not been annexed by me. But it has not been communicated to me. For that, for verification, I took time. That has not been communicated to me except this letter. That might be available with the office of the district judge, but it has not been communicated to me. No other, nothing else. After verification, I found that no order has been communicated to me.
What was your prayer? What is
my lord, it is regarding appointment.
Where is your representation?
Yes, my lord. This was disposed of. My lord, kindly go to the page number 53.
No, this order which you are showing,
yes,
was in page number 55.
Yes,
it states about 4 representations.
Which
you have annexed perhaps at annexure 9 series.
Yes, my lord.
Annexure 9 series, and the last one is, let us say, 7/9/23.
Yes,
that is the latest one.
Yes.
What you have written there?
That is for giving appointment in the class 4th post, my lord, in the Baleswar Judgeship. My lord,
why you will be given appointment?
My lord, there were 27 vacancies. Yes. My lord, kindly come to the shortlisted candidate, shortlisted list at page 12. Now, page 16.
Yes.
Yes. My lord is at page, my name is at page 16.
This was in the year 2013.
That was,
What you are doing after 11?
no, my lord, that was stayed. That was stayed.
Huh?
That was stayed by my lord. That was stayed.
In which case it was stayed?
It
And
was,
what order was passed in that case?
yes, my lord, this is the stay order vacated. After that order was vacated, they had given appointment to one person, my lord. I have an annex also.
This was not pressed for.
Surya Kumar Mahanti and others had filed it.
Yes.
They did not press for it.
They did not press for it, was dismissed. After that, the stay order was also vacated.
So,
That has been annexed by me also at page 28, 29.
yes.
I had approached before the my lord in the year of 2019. But that writ application was withdrawn with a liberty to file in another representation. That representation was disposed of, my lord, Annex 10, page 51.
No, where is your name in this list?
My lord, page 22, na list 22, 60.
No, you upon 16, 17 among the three.
22 number.
Yes.
Rajesh Kumar Mishra.
What is the total number of posts?
27. 27.
So how many got there?
15 have been given appointment, rest 12 have now been.
So thereafter, after this list was published, what has happened?
My lord, because after giving 15 persons appointment, the matter was stayed. So no further proceeding processed in that office. After stay was vacated, one person approached the Honorable High Court, the retrenched person.
Now you see that in the last line of that annexure 3, it is mentioned that this merit list shall remain valid till the advertisement of vacancy for the next recruitment to and group D post.
Yes,
So that must have been done in the
no.
No further advertisement is there.
To 2013
No, sir. Seta valid ଅଛି ସେଇଟାରୁ ଦଉଛନ୍ତି.
Rule change.
I will find out, my lord.
हाँ, just
My lord,
please.
kindly come to page 28. please. 28. My lords, the self-same recruitment was under challenge, and this is the order of this honorable court.
That was, no, my brother is wrong to that action. My lord, there were 49 selections. The list so that 47 candidates were listed. But here the case was after 27 posts, the rest were ignored. Only 27 posts case is to be considered, but the rest 47, rest other persons, but 22 persons who are in the shortlisted, that case cannot be considered because they were not in the as per the vacancy.
So that's one aspect, but this list which we are putting your question.
Yes, my lord.
That the list which you showed us is that page number 20.
28. 20.
16, my lord.
No.
The list is
Annexure 316, man.
16.
Yes, my lord. Page 49. There are total list of candidates 49. Since they were not as per the vacancy 27, beyond 20.
You mean to say that out of this annexure 3 list,
my lord,
15 persons were given appointment.
My lord.
But your number was 22.
My lord.
And this list was valid up to
next selection.
Next. That, but you said that that recruitment to group D post has not yet been made in that just.
No, man.
We take this instruction, we can
7 days time.
matter next week.
that letters we do not know.
Land counsel for the petitioner. As per order dated 22/4/2024, the land counsel for the petitioner took time to submit some documents along with affidavit of the petition. The land counsel for the petitioner submitted that since the rejection order by the annexure 11 has not indicated any reason for rejection of the representations of the petitioner, he took time to obtain instruction as to whether the authorities have assigned any reason in any document for rejection of the representation of the petitioner or not. But he has obtained instructions that the authorities have not assigned any reason in any document for the rejection of the representation. The Learned Council, drawing the attention of this court to Annexure 3, which is the combined merit list of successful candidates, both general and reserve categories, in connection with the recruitment of Group D PACE level post in the Justice of Baleswar, which was held on 21/7/2013, submitted that the name of the petitioner finds placed at serial number
22, my lord.
22, and out of that list, 15 persons have been given appointment in the Group D post. In the end of that merit list, it is mentioned that this list, that such lists shall remain valid till the advertisement of vacancies for the next recruitment to Group D post in the Justice. This list is dated ऊपर लिख रहा था जो 21/7/2013 वाली है ना. Since in the meantime more than 11 years have passed, and it is the contention of the Learned Council for the petitioner that thereafter no recruitment to Group D post has been held in the Justice of Baleshwar. Learned Council for the state seeks some time to obtain instruction in that respect. Put up this matter next week. Okay.
Oh, bless you.
Item number 2.
Mr. Bhutta, Union of India, nobody is there.
2 matters are there.
So from
Item 3.
TVC, Union of India.
Item 4.
Petition is Lonnie Miller. Now, auction notice has been issued on the amount 53,38,200 rupees. I am ready to, already I have paid 1 lakh and rest 4.37 I will deposit. Let notice goes in local adult, I will settle the matter. My residential house. Lakshmi, see page 8.
No, this is simply possession has already been taken. So your
that I know. We will go, my lord, if you will deposit entire money, negotiation is going on.
Maybe we will not entertain this matter because of this.
My lord, we are only lordship say.
No, you have got alternative remedy. Why will you entertain? It appears from annexure, the petitioner's prayer is this. It appears from annexure 1 that possession notice was issued on 21/9/2023 by the authorized officer. Since the petitioner has a decision would have court order, we are not inclined to entertain this petition disposed of. Yes, next.
My lord, our name may be repeated. Our presence.
Please give the in the name. Please.
Pardon, my lord, item 2 and 3, my lord, on behalf of Mr. Bhutta, my lord, pass over, my lord.
Oh, we have already passed over.
My lord, oblige, my lord.
Item 5.
Can you pass over, my lord?
Let me solve a copy. Give a copy, we'll take up this matter next week. Okay. Land Council for the state submits that the land petitioner, Land Council for the petitioner has not solved a copy of the writ petition to him. Let a copy of the writ petition be served on the Land Council for the state matter be listed next week. Huh? Yes.
Item 6.
Yes, Mr. Ghosh.
Millard, 6 Millard, I pray 2 weeks time. Because Mr.
Any
Senior
interim order has been passed?
No, senior advocate may.
No, it's just we want to know about the interim order.
No interim.
All right. Mr. Ghosh, Land Counsel, appealing for the petitioner, seeks for an adjournment for 2 weeks. Put up this matter after 2 weeks. Yes. Give the date. We commencing from. Yeah.
Item 7.
Mr. Kashyap.
My lord, in this case, can it be adjourned to next week, my lord? It's required some because because last occasion I took time.
All right.
Again.
Pari Ranin, Deputy Solicitor General, India, 6 for an adjournment. Till next week or a week after? Mr.
Next week after is better.
All right. A week after, please this matter. Week after a proceeding. All right.
Item 8.
Mr. Sundar Das.
May I please your lordship? Pass over, my lord. It will be taken.
All right.
Item 9.
9, Mr. Marma. Here.
Please, lordship, kindly see the last order. The lordship directed my learned friend to take instruction in the matter. P1024.
Mr. Das, Amitabh Das,
Mr. Das,
State government is
no road.
State government is to execute the work in question and all right, Land Counsel for the petition submit that earlier the petitioners approached this court in so and so for a direction for compliance of the procedure in accordance with the provision of law provided under NHR 1956 and right to fair compensation.
They have already compensation paid, my lord.
Just a minute. The said retribution was disposed of with a direction that the grievance of the petitioner shall be considered taking into account the instruction of the government issued so and so, as expeditiously as possible, preferably within 6 weeks from the date of communication. In this writ petition so and so, it is stated that in spite of such order, even though that was communicated on so and so, but nothing has been done so far, therefore, the petitioners have filed a contempt petition so and so, which is sub judice. And now the opposite parties are taking all steps to dispossess the petition.
Well, already they have given the
The amount which I have received, I have annexed. My friend is showing that which I have received. That is not the amount. 80% they have to pay as per paying 73.
This is the last order, my lord, as per the direction.
So the crux of the issue is that whether the notification of the government under Annexure 9 as page 72 has been taken into account for the purpose of competition or not. That was
9/10/24 would order issue. Case is taken up for hearing so and so. The contention of the learned advocate is that the following schedule so and so. By the they have gone through the documents available so and so. It is revealed that the hour of compensation also made taking into account the land value so and so with regard to the instruction.
Yes, yes. So it has been taken.
Evident or already been compensated.
Yes, yes.
Done toward the compensation. Also the claim of the petition regarding non-payment of funds and moment. So this is the latest order.
Page 61, lordship, kindly have a glance.
60.
Whatever I have received, that I have reflected page 61 of the brief. A person's entire
when you filed this writ petition,
I have filed this third occasion. I filed this 17/9/24, madam.
This order was passed on 9/10/24.
9/10.
9/10/24.
This 9.
Yes, my lord. After your lordship passes this order.
Yes.
So,
my lord.
If anything you want to say on this order, you are supposed to either amend your writ petition or file a fresh writ petition.
What is my case? Perhaps I am not clear to me.
Whatever it may be, this is the latest order passed.
That I am, my lord, I am aware of it.
If you are
after your
aware of
lordship
it, then
passes,
take steps accordingly.
After your lordship passes order, they have issued this.
So are you supposed to amend your writ petition or not? The prayer which you have made, they have taken note of it and they are passing this order against you. Are you supposed to take?
Well, I have not yet been received that
yeah.
copy.
That is the thing,
My
because
friend
they have
should
taken
serve a
into
copy
account.
first.
All
My,
right.
my friend
We
should
are just adjourning the matter.
my friend should serve a copy of that.
The in persons of the order dated so and so 3/10/2024, and counsel for the state has produced the order dated 3/9/10/2024 of the arbitrator from Collector Koraput, wherein it has been mentioned as follows. For gone through a rejection for the land counsel for the petitioner submitted that since it's not having the copy of the order dated so and so, let a land counsel for the state be asked to serve a copy of the order. Let the land counsel for the state serve a copy of the order dated so and so. Put up this matter so and so for taking instruction in the matter. They are copied out. Yeah.
If my friend kind enough to give me a copy, in the course of the day, I will file the reply. I'm grateful to you.
Item 10.
My lord, item 10, my lords, remember similar cases, though I tried to convince my lords on the merit.
Which is the number? Please give one copy so that.
My lord, I will give it. Just before vacation also, my lord. Similar. Item 53 also same.
53.
53, the same order. Please hand over a copy, Mr.
Ma'am.
Item 11.
Union of India.
Yes, Mr.
May challenge the order of Central Administrative Tribunal at page 18. Order page 18. Order dated 28/8/2023. Here, my lord,
Just come to the prayer which was made.
Yes, ma'am.
Page number 19.
My lord,
See the prayer. Just read it out.
to direct the respondents to settle and disburse the legitimate dues of the applicant, that is leave salary, gratuity, CGIS, and other retirement benefits, keeping in view the decision of Honorable CAT Principal Bench in case of Kuldeep Singh and DOPT OM dated such and such in an early date, and further be pleased to direct the respondent pay interest and delayed payment of gratuity, and that should be recovered from the hearing official who has delayed the matter. Pass any other order as well and allow this back.
Now, please come to the operative part. Then you address us.
Yes,
come to paragraph 9. Page number 24.
Yes, ma'am. From the above quoted rule, it is seen that either the provision of clause 2 or 4 shall be applicable in case of applicant. No document to the effect to show under which pension scheme the applicant is currently subscribed in state government has been filed. In the said circular, the respondents are directed to examine the case and, if necessary, after due correspondence, take a decision to that effect. If the case of applicant is covered under clause IV of the rule quoted above, then this gratuity dues should be calculated and paid to him. This part has already been
just finish it.
In view of the above discussion, the respondents are directed to pay the leave and encashment due to the applicant and to take a decision regarding payment of gratuity. And if he is entitled to the same, in view of the discussion and rule quoted above, the same should also be paid within a period of 90 days from the date of receipt of the public.
In that case, you are the so you are the Union of
India.
So, what decision you have taken on that order, or you are straightway challenged? The tribunal has asked the Union of India to consider.
Yes, that
and that period is already over. So, yes, have you communicated anything, or you have just challenged that order? That is why you have not taken
that part I have not been challenged. That I have been taken a decision, and we have only in since para 10, Your Lordship. So far as leave encashment due is concerned.
No, about gratuity first, deal one by one.
Gratuity part we have taken a
It is
decision.
mentioned that the gratuity
Yes.
is
We are not
to be
challenging this matter.
calculated and paid.
Yes.
No. Have you considered
Yes,
it or
yes,
not? In
consider.
accordance with the direction.
Consider.
Where is that?
That I have taken.
There is a specific
Yes, yes,
direction.
direction
because
that
you are not challenging that aspect.
Yes.
That is the reason why we want to know
yes, my
that
lord.
how far you have complied that part of the order.
That I have.
Whether you have paid the gratuity or not, because
No,
the time limit was fixed for 90 days from the receipt of the order. That date has already passed.
It doesn't say so. Your para 12 is only saying about the manner in which you are, you simply say that yes, he is entitled, but you are not paying.
If you have not obtained instruction, please obtain instruction in that respect about the gratuity. The other part we will see. But since you are not challenging, according to your affirmance also, please take instruction whether you have calculated that and whether that has been disbursed or not.
That's that part.
Take down. This writ petition has been filed by the Union of India challenging the order dated 28/8/2023 passed by the Land Central Administrative Tribunal, Cuttack Bench, Cuttack in way number 136 of 2020. It appears that the opposite party, Ravindra Kumar Behera, filed the original application before the London Tribunal seeking for the following relief, for the relief in paragraph page number 19 of that writ petition. And after hearing the land counsel for both the parties, the London Tribunal held as follows, quote paragraph number 9 and 10. The London Council for the Union of India fairly submits that the direction of the London Tribunal regarding payment of gratuity to the opposite party has not been challenged by the Union of India in this petition. When we made a query as to whether the gratuity amount has been calculated and whether the same has been paid to the opposite party or not, he seeks some time to obtain instruction. Put up this matter on
1 week after.
1 week after. This matter on such also. Yes.
Item 12.
Writ petition has been filed by the seeking for a direction from the past appropriator on the application. Submit that though the application is made on no or has been about.
Last 2 page, my lord.
Give a copy to him the last 2 pages means annexation.
The authorized officer को मगा है कि submission to service of the copy, authentic copy of the notice.
Just a minute. Submission of authentic. You are showing that third page.
हाँ, गोटेला annex 2, 13/10/2023. Then
this is written by Additional District Magistrate Sundargarh, addressed to authorized officer Tata Capital Housing Finance Limited.
Since 2023, they are asking for the
submission of authenticated served copy of notice so and so issued. Acha. Upon तांको दियो तो copy से instruction नेबे.
They are not serving.
I'll rectify within 2 weeks, Millard. Then the application can be disposed of in another 4 weeks, Millard. That's
subject to rectification of it.
Subject to Millard.
All right. This
I'll provide the information within 2 weeks.
This writ petition has been filed by the petitioner Tata Capital Housing Finance Limited, challenging the inaction of the opposite party, number 1, in passing appropriate order on the application filed by the petitioner under section 14 of the Surface Act 2002 within the stipulated period. When the matter was taken up on 1/10/2024, Land Council for the state took time to obtain instruction regarding the status of the application under Annexure 1. Today, the Land Council for the state has produced the written instruction received from the Additional District Magistrate Sundargarh, in which it appears that the petitioner has been asked to submit the authenticated soft copy of notice under Section 13(2) issued to the borrower and of the Surface Act. The Land Council for the petitioner submits that whatever defects have been pointed out by the Additional District Magistrate Sundargarh will be removed within a period of 2 weeks, and this court may dispose of this petition, directing the collector Sundargarh, opposite party number 1, to take necessary steps thereafter in accordance with law. The Land Council for the state has no objection to such submission. In view of the submission made by the Land Council for the respective parties, this petition is disposed of with observation that in the event the petitioner submit all the required documents sought for by the Additional District Magistrate Sundargarh within a period of 2 weeks from today, the necessary action as contemplated under Section 14 of the Surface Act will be taken within a period of 4 weeks thereafter. Okay, disposed of.
Obligatories.
Item 13.
May I please, Your Lordship? The present petitioner has already been received housing loan of 17 lakhs in 2021, Your Lordship. 30th November 2021, housing loan 17 lakhs. On the same day, outright purchase loan of 21.60 lakhs, Your Lordship.
No, it's all right. Now,
adjourned date,
13/4
notice, symbolic possession notice issued on 7/8/2024, Your Lordship. Annexure 1, Your Lordship. Annexure 1, Your Lordship. No, 13(3), I mean, Annexure 6, delu representation, that is not.
13(4) notice for a
representation I have given to the.
You have not challenged that. You have not challenged that before the DRT.
Before the DRT, Your
Why
Lordship.
you have not challenged? Why?
Your Lordship, it is only residential loan. I am interested to regularize the loan. Regularize the loan.
No permission is necessary from this Court Land Council in view of several decisions, and time to time the Honorable Apex Court is passing the order that such applications should not
my submission.
Remedies available.
Only my humble submission. I consider the representation. I enter overdues. I will be. I am ready to
file this.
Annexure 6.
Challenging the order passed by the authorized officer to bank under Section 13(4) of the Surface Act.
1,12,000 only outstanding.
Position.
On 7/8/2024.
The Land Council for the petitioner submits that he has not filed the appropriate application for the DRT challenging such orders. However, he submits that a representation has been
Annexure 6 running plus 23
before the authorized officer, public chief manager of the bank by Annexure 6
running plus 23.
The same, but the same has not been considered.
Till yet not considered.
Has not been
to regularize because 30 years loan.
Alternative remedy, so and so decision side is available to the petitioner. We are not inclined to entertain this. Also, the petitioner is at liberty to approach the bank for pursuing this representation, and it is up to the bank to consider the same and pass necessary order. We have expressed no opinion on the merits of the representation. Yes, disposed of.
Item 13.
Item 13.
Very please, Your Lordship. Yeah. My prayer is to settle the land under OGLS Act, my lord. At page 15, my lord, already the Tahsildar has recommended for settlement of the land.
When it was recommended?
It is in the year 1981.
So what you are doing till today?
Thereafter, I have filed several representation, and even I have obtained.
So that will save the limitation that you will the order will be passed that in 81 and after 43 years you will come to this court and will entertain this petition.
Well, kindly have a glance to Annexure 5. I have obtained the information from the collectorate Sambalpur, collector office Sambalpur. They have sent it for settlement to the
about the status of the land now. 81 रे आपनको good कौन order टे ହେଇଥିଲା 81 43 ବର୍ଷ ପରେ ସେ ଜମିର ସ୍ଥିତି କଣ ଥିବ କଣ ନାହିଁ ଆପଣ read petition ରେ କେମିତି entertain କରାଯିବ?
They have written it for disposal.
You are satisfied in filing representation, you go on filing such representation for another 40 years and be satisfied with it.
Kindly have a glance to the page 22, my lord.
Yeah.
They have obtained the information of the RTI.
Yeah.
The last one, serial number 5. They have already written it to the Tahsil office for settlement from the collectorate.
This is of 2019 now.
2019. Thereafter, due to COVID-19.
Now will not entertain you pursue your remedy there. This writ petition has been filed by the petitioner Muhammad Yusuf alias so with a prayer for a direction to the opposite party to settle the scheduled land in his favor under OGLS Act. The land council for the petitioner to the attention of this court to the order dated KPKR से जो order था
It is 31/8/1981, page 15.
Page 15. Allah Ta'ala CV author page order dated 31/8/1981 passed by the Tahsildar in which the an area of so and so out of plot number so and so has been recommended for to be leased out to the petitioner on payment of the premier with annual rent, and that was submitted to the collector for order. In the meantime, more than 43 years have passed, and when we made a query to the land council for the petitioner as to why there is inordinate delay in approaching this court, the land council for the petitioner submitted that representations after representations are being filed before the authorities to do the needful, but there was no response from the authorities. And finally, on by the order dated 8/1/2019, the petitioner received a communication from the Deputy Collector Sambalpur, wherein it is mentioned that that it has been addressed to the Tahsildar Sadar Sambalpur for redressal of grievance of the petitioner and to report compliance to the office of the collector Sambalpur and onward transmission to the government in R and DM department Odisha and RDC and D Sambalpur. It is even though such order was passed on 8/4/2019, the petitioner is approaching this court after almost after 4 years, 5 years, in view of the inordinate delay of the petitioner in approaching this court, seeking necessary relief, and in view of the decision of the Honorable Supreme Court in case of so and so, we are not inclined to entertain this writ petition, which is accordingly dismissed. Research assistant, where is a delayed disposal, approach. Yes, next.
Item 15.
If I may please your lordship, I may be permitted to appear before through BC, your lordship. The annexure 8 is under challenge. Page 74. Wherein the allotment order has been passed in favor of the petitioner. But the cost of land for execution of the lease deed has been fixed at the present market price.
No, you just read it out that in inviting the reference of the
inviting reference to subject cited above, I am directed to intimate that your proposal for allotment of IFCO plot number 27, 28 and 29 measuring acre 1 at Industrial Estate Jaraka has been approved by the management to payment of the following deposits. Cost of land for acre 1 acre is 94 lakhs 44,700 rupees. Annual rent 40.
Then you read it out. Then it is made clear.
It is made clear that IFCO is not liable to pay any interest in the amount of money so deposited. After receipt of the above deposits, final order shall be issued as per norms of IFCO. You are therefore requested to deposit the above amount by using online payment gateways within 30 days from the date of issue of this letter, failing which the proposal shall not be considered and it will be construed that you are no more interested for allotment of land and also not interested in any further progress of your proposal.
So what happened thereafter?
Thereafter, your lordship, my allotment as of yet has not been cancelled.
No, that is your case.
That is my case, your lordship. Till date, no intimation with regards to cancellation of the allotment has been provided. And before, if my lord may see the date of annexure, said annexure, 29.
No, did you deposit the amount as has been directed to?
No.
Then?
Before the expiration of that period, the petitioner has approached this Hon'Ble.
What for?
Challenging the said
quantum
raised.
Demand rate. You mean to say that it should have been 25 lakhs?
25 lakhs, your lordship.
How?
As per the circular.
That circular is of 19.
Yes, your lordship.
And this is the decision taken for your case in allotment of 3.
Yes,
so how can you now challenge that one?
Your lordship, my challenge are based on 2 grounds, your lordship.
Yes.
First is that the circular which is of 2019, your lordship. Post that date, no board of directors of IFCO has not passed any revamption of the amount, your lordship.
How could you say? This is the demand that have been placed before you.
Yes, your lordship.
So it is on the basis of the recommendation of the board.
That demand, your lordship, has been recommended. That demand has been raised, your lordship, as per the order passed by this Honorable High Court, your lordship.
Yes.
So there are alternative pleas that I am taking in this writ petition, your lordship. My lord may bring their attention to annexure 4, your lordship, page 38. The operating portion is in page 41, your lordship.
Yes.
Para 3. We have heard learned counsel for the parties and gone through the materials on record. Considering the facts and submissions made in view of the averments made in the counter affidavit, we are of the view that the procedure which has been followed by the opposite parties, IFCO, in cancelling the allotment of land, while the impugned order is just and proper. However, if the petitioner prefers to give today's market price and comes up with a project to be stated within 6 months, it will be open for the opposite parties, IFCO, to allot the land in question in accordance with law.
Yes.
This said order has been passed in 2019. So in accordance to this said order, I had approached the opposite parties in 2019. So the present market value that is being raised in 2024, your lordship, is as per the benchmark value or as per the market value existing in 2024. So there are 2 alternative pleas, your lordship. One, that if the market value is being raised, against my allotment, it shall be raised for the year 2019-2020 because I have approached the opposite parties then and there, Your Lordship. In furtherance to the order passed by this Honorable. Further, Your Lordship, if that the other argument is that as the board of directors have themselves fixed the value of the land as per the Annexure 9, where in page 77, it has been clearly emphasized that for 1 acre of land, the quantum is fixed at rupees 25 lakhs. So,
see, there is no equity in the response of this court because this court has held that the cancellation of your allotment is proper. But the court has accepted your prayer on mercy. And that is how a condition was put that in case the market rate is paid to be fixed by the authority, you have to pay and get the allotment.
Yes, Your Lordship.
This court has on merit, has not denied the cancellation. So, if you want to get the allotment, the amount that has been fixed at the present market value has to be paid. Why it is to be paid in the at the rate that was prevailing in 2020?
Because, Your Lordship, the delay in passing the order of allotment is solely attributed to the authorities, Your Lordship, because the petitioner has timely approached the authorities, Your Lordship. He has also submitted a feasibility of the project intended to be taken over that land, Your Lordship.
As per this order passed by this court, when you approach the authority?
As per my instruction, Your Lordship, it is in 2019-2020.
No,
where is
the documentary proof to that?
Documentary proof, Your Lordship, that the petitioner has not kept any.
How can we say that you approached in 2019 immediately after passing of the order of this court?
Because, Your Lordship, in that said order, a time limit has been fixed.
No, time limit has been fixed, but did you apply within that time?
Yes, Your Lordship.
You say that where is the copy?
The copy, Your Lordship.
Where from this
bowed
court?
out.
No, but that is the basis. So how can you now say that it is attributed to the authority? It is only when you.
No, if you have got documentary proof in that respect, we can give you time.
Yes,
Your Lordship.
Give you opportunity to get it. See that
Yes, Your Lordship.
You are attributing negligence to on the part of the authorities. For that, you have to satisfy us that you applied immediately after sworn. All right. The writ petition has been filed challenging the demand notice. It's not demand notice actually. It is the notice
payment of a premium amount
is order
against
passed by the authority for asking the petitioner to deposit an amount of rupees so and so with annual rent of so and so for allotment of IDCO plot number so and so measuring so and so. सब लिखा है clearly. Annexure 8 page 74. The learned counsel for the petitioners drew the attention of this court to the earlier order passed by this court in WPC number so and so by the order dated 13/12/2019, wherein while holding that the procedure which has been followed by the authorities in cancelling the allotment of land in favor of the petitioner was just and proper. It was observed that if the petitioner prefers to give the market price, the prevailing at the time of filing the application, and comes with a project to be started within so and so, it would be open to the opposite parties to IDCO to allot the land in question in accordance with law. It is the contention of the land counsel for the petitioner that after passing of the order by this court, in 2019 itself, the petitioner submitted the application before the authorities for allotment of the plots. But the authorities slept over the matter and ultimately passed the impugned order under Annexure 8. when the application made by the petitioner has not been annexed to the writ petition, the Land Council for the petitioner seeks some time to produce such application. Put up this matter. केवे रखियो आपको
My lord, may grant me 2 weeks time.
2 weeks time. Put up this matter on such and such. Yes.
My lord, I filed an IA for no coercive action. My because of the previous allotment,
or we do not know that if that those plots have been allotted to somebody else or not. 30 days was there. That period is already left. You have not deposited a single fine. Yes.
Item 16.
May I please, let's say, challenging the order of dismissal, my lord, in a disciplinary proceeding. The improved order is the annexure 7, my lord. The petition was orderly PM, my lord. When go to the merit of the case, my lord, humbly submits, my lord, he has no case. But 2 disciplinary proceedings prior to that, 1 increment stopped in the first instance. The second disciplinary proceeding, my lord, 2 increments stopped. Thereafter, a third disciplinary proceeding has been initiated against him. My lord, due to absence of duty, he has been directed to, my lord, so he was placed under suspension and directed to report before the London Civil Justice Senior Division, my lord, on goal. He did not join in that, my lord, suspension, but he has not reported his duty. That's why the Honorable London Court below was pleased to place dismissal. What
was the petitioner?
Who has ordered the PL.
So, he thought that it is a private job or what?
No, my lord.
But has he exhausted the appeal provision?
Yes, my lord.
Where is that order? Order in the appellate.
My lord, on my humble submission, the honorable discharge is the honorable.
There is an appeal provision to be taken up by the High Court in the administrative side.
Have you approached?
You approach that.
That observation, my lord.
That's a rule.
The Land Council for the petition, the petitioner has challenged the order dated so and so passed by the London District and Session Judge come Disciplinary Authority on board on dated 14/3/2003, dismissing him from service with immediate effect under Rule 13(9) IX of the Civil Services Classification so and so rule. Land Council for the petitioner submit that since an appeal provision is there against the impugned order, they may be permitted to withdraw this petition to approve the appellate authority. Accordingly, the petition is disposed of. Yes.
Liberty, let's say, my.
No, it is there.
Item 17.
My lord, the petitioner approaches this honorable court against the order of rejecting the claim of the petitioner of retirement benefits on the ground of delay, without touching the merits of the case, ignoring the factum of bona fide relating, that is, impugned order is annexure 10 as per 47. Ignoring the factum of bona fide relating to his acute illness, long time, and ignoring the medical certificates.
Please come to page number 49, your prayer portion. That is quoted there.
Yes, ma'am.
Internal page is 3 and running page is 49.
Yes, yes.
Your prayers have been quoted. Just read it out. That was your prayer in way.
Yes. The respondents be directed to show cause as to why the order by the annexure 6 and 7 and 8 shall not be quashed. The authorities be directed to re-examine the applicant's claim through medical board or whatsoever they like, and the applicant must be given the opportunity of personal hearing, and the period on which the applicant was absent in duty be treated as an extraordinary leave and regularize the services of the applicants. The authorities further be directed to consider the appeal filed by the applicant with pending before them on the ground of humanitarian point of view, and to pass any other orders and orders.
So you come to the now operative part. Those decisions have been quoted therein, and the last decision has been that of that Postmaster General versus Living Media India Limited, page number 59, internal page 13, paragraph 12.
Yes. The Honorable Apex Court of this Postmaster General Living Media
India Limited versus such and such dismissed an application for condonation of delay of 420 days delay in filing the special petition and held that the condonation of delay is not an exceptional and it should not be used as an anticipated benefit of the government departments. The court also discussed several authorities on the subject to arrive at the conclusion. The court reiterated that delay should not be excused as a matter of generosity in view of the fact
So,
that
in this case, you filed a MA for
Yes,
condoning
yes,
the delay.
yes.
So, what is the delay period actually?
Delay period is, my lord, fact is like this.
Have you filed that MA application here to see that what is the delay?
Copy of the MS
Copy of
certificate
the-
No,
copy of the-
I have not annexed here.
That is also
No, that is necessary because on that ground your petition was dismissed. Way was not hard on merit. It was
Yes,
dismissed on the
yes.
ground of delay. So let us see that
And,
what you have explained,
yes,
in what way you have explained.
Yes,
your,
I will file it here.
so
Lord.
file and we'll take up this matter next week. What is there?
The fact is like this, since 2001, in month of
No,
November.
we understand. It is not rejected on merit. It is rejected on the ground of delay. So since in MA you have explained in detail the reasons for that delay, we want to just to see that MA.
I will file MA
Right?
through by memo.
We will bring it next week. The moment you file MA,
Yes, yes.
This writ petition has been filed challenging the order passed by the
Central
Administrative Tribunal, Cuttack Bench, Cuttack in OA number so and so, in which the tribunal dismissed the MA number 34 of 2024 and consequentially dismissed the original application on the ground of grossly barred by limitation. The Learning Council for the petitioner submits that in MA number so and so, the petitioner has explained the reasons for delay in filing the original application. However, the copy of the MA has not been annexed to the writ petition and he submits that he will file that MA with a memo during course of this week or a week after, during course of this week. List this matter immediately after such MA copy is filed with
Your lordship may post it to next week. I will file in this.
Okay, this we filed, list this matter next week. A copy of the MA be served on the Learning Council for the, you have given a copy to the central government?
Central.
A copy with the council, nobody has paid.
Which item? My lord. Yes, my lord.
ଅନ୍ଧାର ହେଇଯାଉଛି
ମୁଁ ଭୁଲ ମାରିଦେଲା ସେ ପଳଉଛି।
ଆଚ୍ଛା ହଉ ଇଏ ଏଠି କାହା ନାଁ ଲେଖିବ ଆପଣଙ୍କର ସେଇ MA କପିଟା ଆପଣଙ୍କୁ ଦେବେ ଯେ
Lordship may reflect my name.
Thank you.
Let them serve the copy to the office of DAS.
Mr. ପାଢୀଙ୍କ ନାଁ ଇଣ୍ଡିକେଟ କରିଦେବେ ବ୍ୟାଟର
ଅଫିସ ଦେଇଦେବେ ତ ରିସିପ୍ଟ ଦିଆହଉଛି।
Alright, yes.
Item 18.
I can file the MA along with the counter na dରକାର ନାହିଁ।
No, ଖାଲି MA ର ସେ ଗୋଟେ objection ଦେଇଥିବେ ନା ଆଚ୍ଛା MA and the objection ଦିଟା yes.
My lord, I may be excused, my lord. In this case, typographical mistakes are there in my body of this case, my lord. For better application, file liberty that.
You want to withdraw this? The Learning Council for the petition submit that since there are typographical errors in the writ petition, he seeks permission. He takes withdraw this answer to file a better. Liberty is granted to the petitioner. File a better application. Already, petition is disposed of with such liberty. Yes.
Item 19.
May I please, Lordship? Challenging the arbitrary action of the opposite party number 22 for in constructing the railway overbridge over the land of the petitioner, my lord, without acquiring the same, my lord. My lord, land is questions, my lord, decretal property of the petitioner, my lord. I annex the
filing na na.
My lord.
ଏପର୍ଯ୍ୟନ୍ତ compensation କିଛି ମିଳିଲାଣି ନା ନାହିଁ?
ନା ମିଳିନି।
କେବେ
11/1 ର ନୋଟିସ ଟା ମୁଁ ଆନେକ୍ସ କରିଛି।
କେବେ ନୋଟିସ ହେଲା?
13/6/24, my lord. Annex 5, my lord. My lord. In that notice, my lord, the above land are not mentioned, my lord.
No, what is your case? This part of land has already been acquired and you have not been paid compensation?
They
Or you want this land to be acquired?
My lord.
What?
My lord.
Probably you want that this land be acquired by the authority.
My lord.
Because a portion of the land has already been acquired. So how can we insist?
Not exactly, my lord.
Then?
My lord, land in question, sir, my lord, as a decretal property of the petitioners, my lord.
All right.
My lord, they demarcated those land.
Come to your representation, annexure 4, last paragraph. Page number 35, on the above premises, that is your application.
My lord, your lordship kindly see paragraph 3 for a moment, my lord.
3 put them.
Page 34. Last paragraph.
ଆପଣ last ଟାକୁ ଆସୁନାହାନ୍ତି ଆପଣଙ୍କ prayer ଟାକୁ ଆସନ୍ତୁ କଣ on the above premises ଆସନ୍ତୁ.
In the fact and circumstances, it is quite
No. You come to that.
The applicant must humbly request your good office to make necessary amendment in the said report, and the applicants both the record and decretal land may be verified properly basing upon the records, giving opportunity of being heard so that the applicant will be in a position to entitle due compensation in respect of his land in the event of acquisition, my lord.
Okay.
Thereafter, my lords, under section 5, under annexure 5, my lord, section 11(1) notice has been published, my lord. My lord, in that notice, my lord, they have not mentioned the land of the petitioners, my lord.
So, what is now your prayer?
My
that means your land has not been acquired by the authority. So why they will pay compensation?
By now, my lord, that lands have been recorded in the name of government, my lord.
So that is altogether a different thing.
My lord, petitioners have filed a mutation case, my lord. That has been not considered by the Tahsildar, my lord. Thereafter, the petitioners filed a writ petition, my lord. This court also directed the Tahsildar to for the mutation, my lord. Since the Tahsildar not mutated the land, my lord, petitioners also filed a contempt, my lord. After filing of the contempt, my lord, they hurriedly preferred an RFA. RFA has been dismissed in the meantime. They preferred a second appeal, my lord. That has not been admitted, my lord.
It's all right. Is that land has been recorded in your name?
No, my lord.
That is not recorded. How will you get the compensation? If a particular land which is stated to have been acquired by the government, if that is not recorded in your name, how for that piece of land you will get the compensation?
Civil court decree is in my favor, my lord.
No, then what is the problem that in the mutation, if the civil court decree is in your favor, if that civil court decree has not been challenged in the higher
They
forum?
challenged, my lord. They challenged.
So what happened?
RFA has been dismissed. Well, RFA filed by the state has been dismissed, my lord.
Thereafter?
They preferred a second appeal, my lord.
Yeah.
That has not been admitted, my lord. Recently, they have filed, my lord.
You have stated all those things in the
lord.
petition.
My lord.
But then this is not the time for them to pay the compensation also until it is finally.
Yes, what is that second appeal number? First appeal order कहीं?
I have not understood.
हाँ?
No.
क्या चल
Dismiss
first appeal contesting is ना का कौन क्यों?
सेटा dismissal admission stage रे.
order कहीं? अपन गोटे claim टा base କରୁଛନ୍ତି ନା ମୋ favor ରେ decree ହେଲା ତା against ରେ ସେମାନେ first appeal prefer କଲେ first appeal dismiss ହେଲା second appeal prefer କରିଛନ୍ତି which is sub judice.
I am file better application.
हाँ. देखो the writ petition has been filed with a prayer for a direction to the opposite party. Opposite party number 2 to acquire plot number so and so for construction of so and so, and do the prayer directly and for payment of adequate compensation. The land council for the petitions submitted that as for the decree passed by the Land Civil Justice Senior Division Champua, the scheduled land was the right title and interest of the petitioner over the scheduled land was declared, and the defendants were permanently injuncted from interfering with the peaceful position of the petitioner over the scheduled land. Against such order, the defendants preferred first appeal before which court?
Additional District Judge Champua.
Before Additional District Judge Champua. Have you given that number?
No,
Not
neither, even not the court number. Your read petition doesn't reflect
and,
that.
he has instruction that the said first appeal was dismissed, and thereafter the authorities filed a second appeal before this court.
Well,
However, in the writ petition, there is no averment about the number
And the
and the
first appeal
result
or second.
of the first appeal or pendency of the second appeal. Land counsel for the petitioner seeks some time to obtain instruction in all those aspects and file the documents in support of such contention. Put of this matter.
1 week.
1 week after. 1 week after the great deal. Yes.
Item 20.
Challenging the inaction of the opposite party number 3 in not granting the RR policy benefit to the petitioner, my lord, despite the fact that, my lord, their land have been acquired for the construction of Kanpur Dam irrigation project, my lord. Your lordship, kindly see Annexure 2, my lord. Annexure 2 is the award, my lord. In page 11 of that award, my lord, name of the petitioners are there, my lord.
Yes, just a minute. 11. Oh, तापर कौन हला?
They are not extending the benefit of RR policy benefits, my lord, the petitioners only.
No, have you filed a representation for that?
No, my lord.
Then
Your lordship may grant liberty to file.
The petition has been filed with a prayer for a direction to the opposite party number 3 to extend the resettlement and rehabilitation policy benefits to the petitioner within a stipulated time. It drew the attention of this court to Annexure 2, which is the land acquisition award passed under Section 12(2) of the So-and-so Act 1894. The Land Council for the petitioner submits that the petitioners intend to file a detailed representation before who is the authority? 2.
Opinion number 2, my lord.
Opposite party number 2. Within a period of 2 weeks from today.
My lord.
And if the authorities may be directed to consider the same in accordance with law. The Land Council for the state has no objection. Like there is no objection, but considering the submission made by the Land Council for the respective parties, if any such representation giving all the details of the benefits available under the So-and-so and the entitlement of the petitioner to get such benefit is presented before the authorities, the same shall be with a copy of this order and a copy of the writ petition. The same shall be considered by the opposite party number 2 in accordance with law and shall be disposed of within such and such period, and the result thereof shall be communicated to the petitioner within 2 weeks of the taking of the decision. Accordingly, the writ petition is disposed by.
Item 21.
My lord, the petitioner purchased a piece of land which was acquired under the Land Acquisition Act in the year 2013.
Era kon pending achi?
My lord, my simple prayer is to direct for it to dispose the earlier case now.
Sure,
My lord.
ତାଦେହରେ କଣ ଅନ୍ୟମାନେ appeal କଲେଣି?
Again.
ଆମେ direction ଦେଇ ଦଉଥିବୁ ଦେଖିଲା ବେଳକୁ notice serve ହେଇନଥିବ। ତ this writ petition has been filed with a prayer for a direction to the civil judge, land civil judge, senior division Sambalpur to dispose of LA reference case number so and so within a stipulated period. The Land Council for the state has no objection. 6 months of an occasion. 6 months time after.
If there is no impediment.
If there is no other impediment.
Okay.
Yes.
Item 22.
Yes, Ms. Mahapatro.
Where the claim of the petitioner to provide the benefit of the RR scheme having rejected, this petition has been filed.
Where is that rejection order?
That is my lord under
Annexure 17.
17. Why it has been rejected?
no reason has been given.
No, they say that you are not a displaced person.
I am a displaced person, my lord. They have granted me. Your lordship will kindly see the order.
Just see, come to that order. Let us see. An order has been passed by this court, so and so the opposite parties are directed to take necessary steps for disbursement of compensation, so and so. Accordingly, the land compensation amount of the tune has already been disbursed
Okay.
to Anjali Vera. Anjali Vera means this petitioner. Okay. As for so and so, the petitioner is not coming within the displaced family, and hence he is not eligible to get RR benefit. The same has been intimated. So, what is the definition of that displaced family, and how they say you are not coming within that definition?
That is, my lord, no reason has been given. My lord, when they have acquired the land, there was a house.
No. At least when they are stating this is the reason.
Again.
So you are to at least make averment. Yes, I am coming within because of this reason. I am coming within the definition of displaced family. Therefore, I am entitled to so and so. So, where in which paragraph you have mentioned that?
Lordship will kindly see.
Displaced family definition होची या मोर status होची या तेणु मु displaced family भितर आसुची तेणु मु आरआर बेनिफिट पाइबार हकदार एटा को जो रिजेक्शन करिसेंती दैट इज इलीगल एटा कोर्ट लिखिसन
Kindly don't page paragraph 18, paragraph 18, page 8. I have stated that I have constructed a house over the same and
ना एटा पर आपण ऑर्डर टा कोर्ट हे गेला आपनकर ऑर्डर कोर्ट हैला परे जो डिसमिसल कले अनेक्सर 17 ना अनेक्सर 17 टा अनेक्स कले कोर्ट
that also they have rejected and I have filed a writ application.
आप आगुर कोन हिची छाडी दियंतु
say ground रे say your lordship will kindly see the rejection order
Annexure 17 को आपण जो Annexure 17 को चैलेंज करिसंती ताकू पेज नंबर पैराग्राफ नंबर 23 रे खाली लिखचंती इट्स ए नॉन स्पीकिंग ऑर्डर
lordship will kindly turn to page 31
30
Annexure 12
Annexure 12
is
that was my lord passed by the same authority holding that
what we say that if you have not taken that specific ground, just amend the writ petition and take that ground in one paragraph. That's sufficient. A displaced person of family definition होची या मोर या जोगु मु आसुची ता भितर एतरे कोन आरआर बेनिफिट सेटा को नबा कथा ना अपन लेना दी से ग्राउंड टा
मोर कल टिके कोची टिके देखंतु
अपन ग्राउंड टा नेले सिना रीट रे से माने कहिबे गोटे तार अवरमेंट आसी से माने काउंटर टा फाइल करिवे
before that I have approached this honorable court to extend the benefit of RR policy.
ठीक अछि सब
that was disposed of
with a direction to the authority to consider this see आपनकर consider करी एई रीजन टा देले
नहीं consider कले annexure 12 पे page 30 रे
नो एबे जोटा
टिके
आपण पे कंसीडर हैला एथरे 16/8/2024 रे
ना ता पूर्वरु सेटा जेटा कंसीडर करथिले बाय virtue of the orders of this honorable court that I am not coming under the displaced family that is under annexure 12
से छाडी दियौ आगुर कोन हेछि
सेटा क्लास हैला
एबे वर्तमान
क्लास है कि फर्दर डायरेक्शन होला जे ता एटा को डिसाइड करो बुझी सेटा क्लास हैला जे सेमान सेम थिंग they have stated that I am not coming under the displaced category man.
All right, then you are to satisfy us how you come, and for that you are supposed to take.
So what was your averment in that writ petition? Where is the copy? What was your averment in that writ petition where this court has passed an order? Where is the averment? What is the copy of the writ petition?
Copy of the writ petition, my lord, that is
Annexure?
copy of the writ petition टाକୁ annexure करने के लिए order टाକୁ annexure
ଆଉ ତାହେଲେ କେମିତି ଆମେ ଜାଣିବା ସେ ଗ୍ରାଉଣ୍ଡ ଆପଣ ଥିଲା କି ନାହିଁ ସେଇ ଅନୁସାରେ ଅର୍ଡର ହେଇଥିଲା କି ନାହିଁ? How can we know?
ଏଠି ବର୍ତ୍ତମାନ ଆପଣ ଏଠି ଗ୍ରାଉଣ୍ଡ ଟା ନେଇନାହାନ୍ତି, ଆପଣ ଗୋଟେ ଆଗ ରିଟ୍ ପିଟିସନ ରେ ଗ୍ରାଉଣ୍ଡ ନେଲେ ବୋଲି କହୁଛନ୍ତି, ଯାହାକୁ ଆଜିରେ ଆପଣ ଦାଖଲ କରିନାହାନ୍ତି।
नहीं ସେ order ଟା କ୍ୱାସ୍ ହେଲା ସେ order ଟା
ଅଛି ଯେ ଆମେ ଗ୍ରାଉଣ୍ଡ ଆପଣ ଜାଣିଥିଲେ ସିନା ସେମ୍ ଗ୍ରାଉଣ୍ଡ ରେ ପୁଣି ଏଥର କ୍ୱାସ୍ ହେଲା ବୋଲି ଆମେ ଜାଣିବୁ। Unless you have challenged that particular order under annexure 12 that was challenged before this court. So what ground was taken in your writ petition which has been reiterated here?
Yes,
that has to be seen. Unless we know that that was the ground on which you had challenged, showing that you are inclusive within the definition of displaced family.
displaced person means, my lord, when
Then what we mean will not be there. What is there in the rule?
Displaced
It is definition is there in the rule.
definition.
So whether you are coming within that or not, that you have to justify. So if you have taken the ground in the first writ petition, you may not have taken subsequently because the same has been reiterated. But we must know at the first instance that that ground was taken by you in the writ petition first, nor in this writ petition. In neither of these. Kim janiba?
So better you just one line गोटे paragraph add कर दियंतु displaced family को ये करिकिनु just लिखुन the writ petition has been filed challenging the order dated
16/8/2024
passed by so and so in rejecting the claim of the petitioner to get RR benefits on the ground that the petitioner is not coming within under displaced family. The Land Council for the petitioner submits that the petitioner is coming within the definition of displaced family, and therefore she is entitled to get such benefit, and he will amend the writ petition and take necessary amendments in that respect by filing an interim application, and the matter may be taken off a week after. Put up this matter immediately after the interim application for amendment is filed. Yes.
Item 23.
Yes, Mr. Panda.
Please, Your Lordship, my lord. My lord, here the application is against the action of the opposite party in issuing the notice under section 13(2) of Surface Act in respect of the loan amount that we have been received. So, Adhir Konala, my lord, we have
Then you submitted your representation?
My lord, we have given our representation.
Then what happened?
So, 10/7/2024, we have given the representation.
What happened thereafter?
Tapre 11/7 they have issued the notice. The next day.
What is that? 11/7. Annexure 1.
Annexure 1.
11/7 is the demand notice dated 13(2) of the Surface Act.
My lord.
So after 13(2), you are supposed to give reply or file the representation under 13(3)(a). So have you done it?
Oh, no, my lord.
That is important. Then there is no complaints.
Then
it's premature. You have been allowed an opportunity to explain.
My lord, in the representation we have given that regular EMI will pay it regularly, but the outstanding areas have to be paid in the.
You see, the notice referred to so and so 13(2) shall give the details of the amount payable by the borrower and the secured assets intended to be enforced by the secured creditor in the event of non-payment of the secured debts by the borrower. That is their notice annexure 1.
My lord.
Then 13(3)(a) says that if on the receipt of the notice under subsection 2, the borrower makes any representation or raises any objection, the secured creditor shall consider such a representation or objection, and if the secured creditor comes to the conclusion that such a representation or objection is not acceptable or tenable, he shall communicate within 15 days of the receipt of such representation or objection, showing the reasons for non-acceptance of the representation. So you have got a scope there to submit the representation that you have not submitted. So the authority then can proceed to 13(4).
My lord.
So have you submitted any representation? No, then you file, you have got it. This writ petition has been filed by petitioner so and so with a prayer for a direction to the opposite party number so and so, like this. The learning counsel for the petitioner submits that the petitioner has received a demand notice under 13(2) of the Surface Act on 11/7/2024. However, he submits that after getting such notice, after receiving such notice, the petitioner has not made any representation to the authority as provided under section 13(3)(a) of the said act. And therefore, liberty may be granted to the petitioner to make such representation to the authority, and the authority may be directed to consider the same in accordance with law. It is further stated to us that the no steps have been taken by the authority in the meantime under section 13(4) of the Surface Act. If the statement of the Land Council regarding non-taking of steps by the authority under section 13(4) of the Surface Act is correct, in case a representation is made within a period of 1 week from today against the demand notice, the authorities shall take into account the same in accordance with law and submit and communicate the result thereof, to take the decision thereof, communicate the decision to the petitioner within the stipulated period. It is made clear that we have not expressed any opinion on the merits of the representation likely to be filed by the petitioners before the authority. And it is also made clear that we are passing this order on the submission of the authority, Land Council for the petitioner, that no steps have yet been taken by the bank, by the finance so and so, under section 13(4) of the so and so. Yes. Next.
Obliged, my lord.
Item 24.
Kindly glance to page 4, para 8, my lord. That it is respectively submitted that the opposite party number 2 awarded higher compensation to the adjacent landowners. The opposite party number 2, while determining the compensation amount, adopted pick and choose method in awarded more compensation to the land users of same locality. Even the opposite party awarded much higher amount to the adjacent personers.
ଏଇଟା କଣ ହେଲା ଏଇଟା ଗୋଟେ
ମାଲାଟି
କେବେକାର ଏଇଟା 2023 ମସିହାର
2023
କଣ ହେଲା ତାପରେ କ୍ଷତିପୂରଣ ବାବଦକୁ ଏତିକି ରାଶି ପ୍ରଦାନ କରାଯିବା ପାଇଁ ସ୍ଥିର କରାଯାଇଛି। ଆପଣ ତାର ଶୁଣାଣି ବାବଦ ଆପଣ କଣ ହେଲା କଲେ?
Annexure 2 ଗୋଟେ ଦେଇଛନ୍ତି
ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଛୁ, ରିପ୍ରେଜେଣ୍ଟେସନ କିଛି କନସିଡର ହେଇନି। Annexure 3 ସିରିଜ ଟା ପେଜ 10 ଟା କମ ଆମାଉଣ୍ଟ, ପେଜ 11 ଟା adjacent plot to higher amount.
ରିପ୍ରେଜେଣ୍ଟେସନ ପେଣ୍ଡିଂ ଅଛି, ଏପର୍ଯ୍ୟନ୍ତ କିଛି ହେଇନି।
କିଛି ହେଇନି।
Representation dispose of
opposite party number 2.
Take to submit, my lord. He has already received the compensation.
Redetermination ପାଇଁ କହୁଛନ୍ତି।
Redetermination, there is a provision.
Yes, yes, there is a provision.
He has to file application before the collector, and accordingly the collector has to decide and take a decision.
So where is that?
The 3G5 section 3G5.
No, where is it? Has he not filed?
No.
ଆପଣ ସେଟା ରଖିଦେଲେ। Collector is the arbitrator for that purpose in NHI. So
the petitioner has filed this writ petition with a prayer for a direction to the opposite party number 2, that is so and so, to redetermine the award of petitioner compensation, taking into account the benchmark as well as the market price it is submitted by the counsel for the petitioner that the petitioner submitted a representation in that respect by the annexure 2 before the authority that is so and so, but no response has been received. However, the learned counsel appearing for the, you are appearing for whom? For the National Highway Authority submitted that the petitioner has already received compensation and if he is aggrieved by the quantum of compensation, then recourse is available to him under section 3D5 of the NH Act 1956.
Before the collector and arbitrator.
Before the collector, arbitrator. The learned counsel for the petitioner submits that in view of the availability of the of such provision, the petitioner seeks permission to withdraw this writ petition to approach the appropriate authority for enhancement of the quantum of compensation. In view of such submission, the writ petition is disposed of, giving liberty to the petitioner to approach, seek for appropriate remedy. Yes.
And I may pardon, I will prefer.
କରିବେ ନ କରିବେ ଅବିକାଠୁ ଆମେ ଡାଇରେକ୍ସନ ଦବା ଏତେ ଦିନ ଭିତରେ ଯଦି ଆମର କଣ ଏଇଟା ଶୂନ୍ୟରେ ଦଉଥିବେ ଏତେ ଦିନ ଭିତରେ ଦଉଥିବେ ତାପରେ ସେତେ ଦିନ ଭିତରେ ଜଣେଇବେ ଆଗେ ଫାଇଲ କରନ୍ତୁ ତାପରେ ଡେରି ହେଲେ yes
And 42 is same. 42 same area.
Yes.
Another petitioner.
42 same. Yes.
Obliged.
Item 25.
My lord, OGLSN matter, the representation pending will have the item. Item 25, 26.
annexure number ଟା ଠିକ ଲେଖା ହେଇଛି ତ
ଆଜ୍ଞା
ବାହାରକୁ ଯାଇ କହୁନାହାନ୍ତି ବାହାରେ ମୁଁ କହିଲି ବାହାରେ ଫୋନ କରି କହିଦେଇଥା ସେଠୁ କଣ କହୁଛନ୍ତି if you are tell something come here and tell you make yourself what is annexure
ସମାନ ଅଛି
ନାଇଁ ଆପଣଙ୍କୁ କୁହା ହେଇନି ଓହୋ
correct next yes Mr. Khatua
my lord
give that
item 25 26 28 29 and 30 my lord
କୋଉଟା item
I beg your pardon my lord item 25 26 and 30 that will representation before the Khurda district collector
collector
and 28 29 is different one is at Kotak and another is at Baleshwar
anyway opposite party ki achen sir dekhi ki dela ho opposite party number 3 कोठी
annexure 3 टा
जो कोठोंटी 25 26 ଆଉ
30
ଟା ହଉଛି
ଖୋର୍ଦ୍ଧା
ଖୋର୍ଦ୍ଧାରେ
opposite party number 3
opposite party number 3 हां
28 and 29 28 ଟା ହେଲା କଟକ 29 ଟା ହେଲା ବାଲେଶ୍ୱର
order same ରହିବ yes next
Item 27.
May I please your lordship? Order under Annexure 6 is under challenge. That is an order of the DRT condoning the delay. I am the auction purchaser.
So you have got alternative remedy at Calcutta?
My humble submission that section 8 doesn't apply here because this is not an order under section 17.
So?
I'm just
No, any order, I think that is the provision.
Any order passed under section 17.
Let us see that.
Yes, section 18, your lordship may kindly see. May I please, ma'am?
Just a minute. Section 18, appeal to the appellate tribunal.
Yes, ma'am.
So
any person aggrieved by any order made by the Debt Recovery Tribunal under section 17 may prefer an appeal along with such fee so and so. Your lordship may kindly come to section 17. Any person, including the borrower, aggrieved by any of the measures referred to in subsection 4 of section 13 taken by the secured creditor or his authorized officer under this chapter may make an application to so and so within 45 days.
So only the measures under section 13.4 can be challenged in 17, and 17 order is confined to section 17.3. What order the DRT can pass, and this order, particular order condoning the delay, doesn't come on within
No,
section.
it must have flown from that 13.4 application. 13.4 application raw.
17.1 application.
No, 13.4 application, 13.4 जो order ही थी वो, that order must have been challenged in section 17.
17.1.
Section 17 file करिया जो stipulated period थी वो, ताकू condone करिया पाए application टा दिया ही तो जो उड़ा उसे condone करी जाए.
Section 5 of the Limitation Act.
Right. So it flows from that 13.4. How do you say that it is totally different?
My humble submission, this doesn't come under section 17. And this court in a writ petition.
Please show us the section, section 17 application, which has been filed.
OA.
Yes, OA. In that OA, no, you have to file it, not that.
I have not filed that because it is voluminous one.
You have to file it, that OA, you have to file that application on which this order is passed, and you show that no, this is not.
That application I have. In fact, in a decision of this division bench of this court, entertained a writ petition and has set aside that order. Your Lordship may kindly see those.
Which decision?
Decision of this court. That Limitation Act is not applicable to surface applications, and a writ petition was entertained. Paragraph 2, madam, of that decision. The Urban Cooperative Bank Limited has filed this writ petition challenging the order dated 9th April so and so passed by the Debt Recovery Tribunal Cuttack in MA number so and so. And that application is regarding condonation of delay and discussing the factual aspects and the law laid down, referring to the Supreme Court decisions.
Which is the Supreme Court decision?
Well, paragraph 25, your Lordship may kindly see. Paragraph 25 of that decision. There, DRT condoned the delay, and paragraph 25. However, what was overlooked by DRT was the applicable and binding decision of a 3-judge bench of the Supreme Court of India in International Assets Reconstruction Company versus official liquidator so and so, year 2017 Supreme Court so and so. There, the Supreme Court has examined in great detail the provisions of the Recovery of Debts Recovery and Bankruptcy Act so and so, which applies ipso facto to the proceedings under section 17.1 of the Surface Act in terms of section 17.7. Then your Lordship may kindly come to paragraph 29. Consequently, the Supreme Court distinguished the decision in A.R. Venugopal on 1st July 15 civil appeal number so and so, which had held that an appeal under section 31 beyond the prescribed 30 days was condonable under section 20 and 24 of the RDB Act. The said decision was therefore impliedly overruled. The resultant legal position is that DRT has no power to condone the delay in filing an appeal before it, either under section 17.1 of the Surface Act or under section 31 of the RDB Act, as can be seen section 17.7 so and so.
So this order now has not been challenged in the higher forum.
Well, my lord, to my instruction, it is not challenged.
So, Mr. Mishra and Mr. Tripathi, you examine this. It has been held that this Limitation Act is not applicable to the DRT. So, DRT cannot condone the delay in filing this 17 application. So, this has been, of course, held by the division bench of the decision. We just want to see that whether this particular decision has been challenged in the Supreme Court or any contrary decision has been in the meantime come from the Supreme Court. Just examine it and we take up this matter. Next week we'll take it. All right, take it. This writ petition has been filed by the petitioner Ratnakar Senapati, challenging the order passed by the Land and Debt Recovery Tribunal Cuttack in IN number 1900 of 2023. ସେ ତଳେ ଗୋଟେ କଣ ଲେଖା ହେଇଛି ଏନଡିଏନ ନମ୍ବର କଣ? ସେଇ ଯୋଉ
डायरी नंबर कौन
एनडीएन नंबर ଲେଖା ହେଇଛି ନା ଡାଇରୀ ନମ୍ବର? ଗୋଟେ ଏନଡିଏନ ନମ୍ବର
से जो इम्प्यून्ड ऑर्डर रे
ହଁ ଇମ୍ପ୍ରୁଭ ଅର୍ଡର।
एनडीएन 1043 ତାଙ୍କ डायरी नंबर टा एसए नंबर हि नथिला सेतु
ଆଚ୍ଛା ନାଇଁ ସେଟା ଏସେ ହୁଏ ମୁଁ କହିଲି ଏନଡିଏନ
ना एटा डायरी नंबर टा
ବ୍ରାକେଟ ଲେଖି ଦିଅନ୍ତୁ ଏନଡିଏନ ନମ୍ବର 1043 of 2024 ଡେଟେଡ ହଉଛି 8/5/2024 in condoning the delay in filing the essay and allowing the interim application number so on and condoning the delay. Land counsel for the petitioner, Mr. Mishra, to the attention of this court to the order passed by this court, division bench order passed by this court in WPC number so and so, party nan likhive, order dated 12/5/2021, wherein it has been held that the DRT has no power to condone the delay in filing the appeal before it, either under section 17(1) of the Surface Act or section 31 of the RTBR. When a query is made by this court to the land counsel for the petitioner, whether this court's order has been challenged in the higher quorum or not, and whether there is any contrary decision of the Honorable Supreme Court, he seeks some time. Land counsel for the state also seeks some time to examine this aspect and apprise this court on the next date put up this matter in the week commencing from 28th of October 2024. All right.
28
mistaken of record for the date of seal market.
30th रे डीआरटी रे पोस्टिंग अछि
28 से पूरा हमें खाली एग्जामिन कर दियो तो दिस अच्छा एक कॉपी ऑफ द ऑर्डर बी हैंड ओवर टू मिस्टर मिश्रा Mr. Mishra, you examine it and he will also.
Item 31.
On behalf of Mr. Das, OLR matter single bench matter.
It is submitted by the land counsel for the petitioner that it's a single bench matter. Let the registry verify the said aspect and the matter be placed before the assigned bench. Yes.
Item 32.
Mr. Patnaik, Achyutananda Patnaik. All right, pass over from them. Next.
Item 34.
It is the income tax matter. It is on the bench with assigned benches. 34, Mr. Jenna, additional government.
34, my lord.
Same one.
I'm sorry, my lord. Probably I mentioned
56 or something like that.
same matter.
So this is also there.
My lord.
34 is covered matter.
Acha.
During lunch hour, I'll give the same similar order.
50. Acha 53 done way.
53.
53 plus this also.
Acha. 30.
So किए नहीं थिले सेतेबेले पीके साहू पीके साहू इंटिमेशन दे देबे जे 10 नंबर टा संगे रे 53 टा केवल पड़िथिले मिस्टर मिश्र कनेक्टेड बेली 34 मध्ये कनेक्टेड तेनु सेम ऑर्डर है ना।
Item 35.
35
Yes, Mr. Mahapatra.
minutes 35 minutes arises out of minutes an order passed by the commissioners coal bearing under coal bearing act minutes constituted by Honorable Supreme Court. Minutes there Honorable Supreme Court says that if somebody is aggrieved by the order of the minutes tribunal, if the read should we can prefer the read. This is the order minutes and that is what we have filed because we are aggrieved by the order in Annex 1. What's about
This is order against order of the claims tribunal.
Not claims tribunal matters. That is usually it is called claims tribunal.
Claims commission.
Claims commission. Yes.
Justice Mahapatra is there.
Yeah.
Justice Mahapatra. Earlier, Justice Paricha was there. Then Supreme Court minors required Justice
Whether
Mahapatra.
that is extended or that.
No, that extension minors is pending consideration of the Honorable Supreme Court. Hard and judgment order is this is the order. Now that is what
August masere bodhe.
August mas it was end by 8 August. Thereafter a petition filed for extension. Honorable Supreme Court had it judgment reserved.
And they are
So that is what we are not able to even get certified copy. That is what minors have given that order, that is awaiting minors decision of the Honorable Supreme Court.
What do you want now?
Well, so the case is very simple. One Sahoo is the owner of 2 plots. Well, coming within that village minors where the coal bearing is there.
So according to this, High Court can entertain
This
petition
reference.
against the order of the
Yes, ma'am. Yes, ma'am.
Claims Commission.
Yes, madam. Under Annexure 1. Annexure 1 minors what happened? May I say minors can be permitted to say minors 3-4 sentences but to appreciate the detailed facts. One Sahoo is the owner of the land. That the particular property situated in the village where the coal bearing act.
Here, what are you challenging here?
Challenging minors some third portion claiming
9123 order.
9123 order. That is at Annexure 1 minors plus 21. Now, may I say in gist minors. One Sahoo is the owner of the minors property. A commission minor, the Sahoo was blessed with one son only. No daughter. Commission minors made the survey and submitted the report. In that is the petitioner is the only son is entitled to the benefit. Accordingly, benefits were extended. 50 as per the law minors, as per the practice minors, 50% in my account, 50% will be kept by the company, to be kept in fixed deposit in a nationalized bank. This has been complied with. Thereafter, during that survey, proclamation was made, inquiry was made, no allegation concerning that yes, Sahoo was blessed with a daughter. All of a sudden, few of the persons came that we are the children of Sahoo's daughter, and they claim 50% out of the total benefits. Though the benefits already have been extended, they claim 50% of the benefits. Their minors Honorable Court issued notice. My lawyer appeared and required the document to be provided. There is no order to provide the document, but the document to be provided to the council for MCL. So on the date of the hearing, minors, the council also did appear. Expect an order passed that 50% of the total amount will be given to those persons. So my humble contention, the declaration whether the person concerned, those who are like Sumitra, Sumitra claimed to be the daughter. Sumitra is no more in the earlier one. Their children are coming and demanding that we are entitled to 50% because Sumitra is the daughter of Sahoo. We say Sahoo was not blessed with any daughter like Sumitra. So that is what minors the commission would have said that you go and get a declaration of competent civil court. Instead, minors allowing that, basing upon the minors legal error certificate, minors know that
on what basis
the basis is that legal error certificate is produced. Though it is minors, it is suppose minors consider for the moment that yes, legal error certificate holds good. So for that compensation, it doesn't hold good. One part. Second part, you should have inquired whether the legal error certificate has been issued, giving notice to me or not. This is the only competent civil court to decide whether Sahoo was blessed with a son, daughter, Sumitra.
No, so the entire amount has been already disbursed in your favor.
50% as per procedure, they kept it in bank account, fixed deposit account.
Right.
Now what happens? By virtue of this direction, now the bank is required to deliver that amount. Once this amount goes, I am completely bankrupt minors. 50% of course I have got. So my humble prayer minors as an interim, this amount may be kept as it is in the bank till a decision taken. It's a very fundamental thing, my lord. Suppose somebody claims that I am daughter of such and such. He has to go to the civil court for a declaration. And in the present case, the commission followed the procedure of proclamation, required inquiry, field visit, required inquiry. During the said period, Sumitra was alive and never raised any objection that I am the daughter. You have submitted the report before the Honorable Supreme Court. Honorable Supreme Court accepted it. You determined the compensation, and compensation amount has been paid to me, of course, in two different processes. One 50% in my account, 50% to be kept in fixed deposit. And now when they are targeting that fixed deposit, there is a direction to release that amount. Who are they?
I say that I was not blessed with, I was not having any sister. So for that purpose, usual thing.
No. Did you produce before when the amount was disbursed in your favor? What was your contention? That you are the only son?
And that is what the report. And that report has been filed before the Honorable Supreme Court. Accordingly, amount has been quantified and released.
Right. The petitioner, Jagabandhu Tajan, challenged the order passed by the Claims Commission dated 9/1/2023 in
so that is called civil case number.
That
number is called
civil case number.
Civil case number 471 of 2019 and 435 of 2019. The operative portion of equally clear. Mr. Mahapatra, when counsel appearing for the petitioner submitted that even though the opposite party's number, so case opposite party's number, 702 12.
Yes.
Except producing the legal aid certificate, did not produce any valid document to show that
their mother,
Sumitra
was the daughter of
Sumitra Puranadavam.
Sumitra
Irgal was the daughter of late Soharu Tajan. The land commission passed the impugned order, which is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the are you receiving the notice on behalf of opposite party number 6, Mr.
Yes,
Land counsel for the state accepts notice on behalf of opposite party number 6, and copy of the writ petition be served on such answers. Notice be issued to the rest of the opposite party by the quick post with proof of delivery. Requisites for which shall be filed within a week. IN number
dispensing with certified copy.
IN number 13757 of 2024. This is an application for stay of
to give the order.
Appropriate order for stay operation of the order dated one. So asked in front. After hearing the land counsel for the petitioner, to also the land counsel for the state, it is ordered that the amount which has been deposited in the bank, which bank it is?
Bank State Bank. Deposited in the bank, I will see
deposited in the bank shall not be disbursed in favor of anyone until further order.
Now, miscase matters that dispensing it certified copy, we are unable to produce it because unless Supreme Court decides matters, this they cannot issue.
Land counsel for the petitioner drew the attention of this court to the order passed by this court to show that against the order passed by the Claims Commission, the petition is maintainable. They said order is taken on record. It so how you land counsel for the this IE
13758
an application for seeking exemption to file certified copy of the. What is the difficulty you are facing?
The difficulty that Supreme Court that has not the commission period has not been extended. That is what they are not able to give a certificate.
The land counsel for the petitioner submits that since the period of the commission has not been extended and the judgment has been reserved in
Supreme Court.
In the Honorable Supreme Court, in case in so and so case, a case number that
is in miscellaneous application number.
Therefore, there is no one to grant certified copy of the informed order. POV submission, the filing of the certified copy of the order under Annex 1 so is exempted for the time being. Yeah.
Item 36.
May I please, Your Lordship? My land was acquired as a notification in the year 2018. Survey was made that compensation amount was paid to me under the provisions of right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement act.
You have already received compensation.
I have received the compensation.
What further you want?
My lord, problem, Your Lordship, kindly see Annexure 10, page 44. That is in what happened, the compensation which I have received, that is due to COVID, I have received in the 2021. Due to COVID, that has not been benchmark value has not been revised. So one of the land loser, he made a grievance before the authority, that is Annexure 10, page 44. Your Lordship, kindly see. Paragraph 2 I am taking.
Representation is there.
My lord, representation is there, but
that is 9/2/2023.
My lord, 9.
You have not received any response.
My lord, no.
All right. Now, Annexure 11 is the representation that's to be disposed of. Yes.
Time limit.
Yes, sir.
Item number 37.
Item number 37, please, Your Lordship.
Yes.
My lords, this is also in pursuance to the directions of the Honorable Supreme Court regarding the Claims Commission, similar as item 35. My lords, here what has happened, I had filed a claims case specifically with a prayer for granting structure compensation regarding a house which was situated on my plot. Your Lordship may see the order of the commission, which is at page 23, Annexure 2. The Learned Commission had directed that an expert team should go. There should be a survey. And as per the survey report, the house existed before the cutoff date. And thereafter, Your Lordship will see the Honorable Commission directed that I should get compensation for the same. Thereafter, my lords, Your Lordship may see the calculation sheet by MCL, which is at Annexure 3, page 25. My lords may see serial number 2. The description is Pakka house with asbestos GI sheet roof. Your Lordship, they have even written the square feet number, even put the amount, and thereafter they have cancelled it. And then there is a remark known as new. So basically, MCL is trying to say that this is a new structure.
Yes.
Yes, which is after the cutoff date, September 2010. So we will not grant you any compensation. But my lords, what has happened here, MCL has neither challenged the order of the Honorable Commission and has, despite the order of the Commission, has not granted me any compensation on the ground that it is a new structure. And my lords, because now after the Supreme Court's, the Honorable Supreme Court's order, all the issues have to be dealt by my lords, which is why I have this writ application has been filed. My lords, the Honorable Apex Court's order is also annexed at page 34. So any issue, the grievance has to be articulated
After
first.
that, you have made a
I have made a representation which is at Annexure 6. It is pending, my lords, but the representation is to the Claims Commission.
Claims Commission?
Yes, to the Claims Commission.
What's the purpose? They have already disposed of.
My lords, they have granted the order.
To disburse the amount.
Which the authority that is exactly my
The authority, my lords, is the collector, my lords, who is the opposite party number 5, the ADM.
Make a representation.
Opposite party number 5.
Opposite party number 5.
Make a representation. This petition has been filed with swans of prayer, and counsel for the petitioner submitted that though a representation was filed before the Claims Commission, Bhubaneswar, since now the Claims Commission is not functioning, the petitioner may be permitted to file a fresh representation before the opposite party number 5, additional district magistrate R.R. Swanso, and may be directed to be disposed of within a stipulated period. Land counsel for the state has no objection to such prayer, considering the limited nature of one. They deve seମିତି time 2 ସପ୍ତାହ ଭିତରେ file କରିବେ, Swanso ଭିତରେ dispose of କରିବେ, result to be communicated to the council. Yes.
Grateful minutes.
Number 38.
Followed item 38, 39, 40, same as item 10.
No, 38, 39, 40. It has item 10 Sahoo ନେଇଥିଲେ either disposal for similar item number 10. Yes.
Item number 41.
Yeah. Please use the mic properly.
My lord, my land has been acquired. Compensation has been determined by annexure 3 page 14, my lord.
তারপর representation ଦେଇଛନ୍ତି
Okay. Till date they have not released, my lord, or not decided my representation.
representation ରେ କୌଣସି response ପାଇନାହାନ୍ତି ଏ ପର୍ଯ୍ୟନ୍ତ
No, my lord.
representation by annexure 4 is pending, it is to be disposed of. Yes.
Within a specific period.
Yes, of course.
Oblige, my lord. Item number 43.
43.
Yeah, for Mr. Himanshu Sahu may be taken up any other day, my lord.
সেটা যাইছে আগে similar.
43 କଣ ହେବ?
Yeah, for Mr. Himanshu Sahu may be taken up any other day next week, my lord. Yes.
Mention is made on behalf of Mr. Sahoo to attend the matter to next week of this matter. Yes.
Item number 44.
May I please, your lords? Here in this case, my lord, this is the third round, my lord. As I have approached earlier in WPC number 8091 of 24, there is a direction to settlement the dues, my lord. Thereafter, again, I have approached in WPC number 16447 of 24. A one-time settlement was directed, my lord. And as per direction of this honorable court, I have entered dues, I have cleared, my lord. Till today, my lord, no clearance certificate has been given, my lord, by the bank.
The direction which was issued by this court on 11/7/24 in that WPC number 16447 of 24. That
Yes,
is
ma'am.
annexed as page number 25, 26.
Yes, my lord. Page
So the
20 to
operative
20.
part, you please come to that paragraph 5.
Yes, my lord.
Yes. Please read it.
Considering the submission made and in the fact and circumstances of the case, accepting the prayer as above, as advanced in the writ petition, we dispose of the writ petition with the observation that if the petitioner files a representation in the above light, the same shall be considered sympathetically and disposed of in accordance with law by opposite party bank before the proceeding further. As per direction, my lord, I went to bank, my lord. I have
Where is your representation?
representation, my lord, page 27.
27.
Yes, my lord.
From Morakita to branch manager.
Thereafter, annexure 6 series, your lordship kindly see.
Representation, how? What happened then?
Thereafter, my lord, the bank given, my lord, to that amount, 6 series, page 29, your lordship kindly see. 8 lakh to 2,755 credited amount. Closing balance, your lordship kindly see, 2,51,032.
Yes.
I have closed the amount, my lord. Thereafter, 2 account is there, my lord. Next, page 31, my lord. I have deposited the slip I have annexed, my lord, page 30. Thereafter, 31, another account, my lord. That closing amount balance is 0.23 tier. I have closed the entire amount, my lord. Thereafter, I have given the page 33, my lord, to given all the documents, mortgage documents, my lord. Again, bank has stated that you have some amount is lying. That's why I could not
So
give.
how we can adjudicate whether you have some account dues or not? They have stated that.
No, your lordship, let them appear, my lord. They have to clarify again and again. They have stated that this amount is there, this amount is there.
He appear କରୁଛି କି ଉତ୍କଳ ଗ୍ରାମୀଣ ବ୍ୟାଙ୍କ ପାଇଁ କି ଅଛନ୍ତି ତାଙ୍କର କାଉନସିଲ କି ଅଛନ୍ତି?
So Panda was appearing last time probably.
The petition has been filed by petitioner so and so for a direction to the opposite party bank to provide a clearance certificate in his favor and to return all related mortgage document of term loan account and CC loan account. The Land Council for the petitioner, referring to the earlier order passed by this court in WPC number 16447 of 2024, dated so and so, submitted that the order was passed giving liberty to the petitioner to submit a representation with a further direction to the opposite party to consider it sympathetically and dispose of in accordance with law. It is a contention of the Land Council for the petitioner that in terms of such order, though a representation was filed by the petitioner on 25/7/2024, but the bank is raising one after another demand. However, the nothing more is to be received from the petitioner. There is no dues against the petitioner, and the demand raised by the bank is quite unjustified. Attention has been drawn to this court to the letter issued by the Chief Manager on dated 31/8/2024. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice shall be filed within a week.
Yes.
Matter be listed on such and so. Yes, ma'am.
Obliged.
Item 45.
Here in this case, the property of petitioner and the opposite party 3 to 10 are acquired under Fuel Bearing Act. Immediately after award under Annex 1, the opposite party 3 to 9 have filed a civil suit. There is a will in their favor. And this in the meantime, the suit has been dismissed. Thereafter, the petitioner 1 filed a representation, and I came before this honorable court earlier, that is in WPC number 1105/2004. This honorable disposed of the repeat said petition directing to consider the representation. And representation under Annex 4, the opposite party number 2 rejected the said representation, stating that, and kindly come page 36.
Yes, we are that.
Stating that since the RFA has been filed challenging the order passed in the civil suit, at present the amount cannot be disbursed.
So you are, let's say, statutory right, they have availed it. So,
but my lord, there is no interim order so far as the disbursement order.
when that appeal was filed?
That appeal RFA number 19 of 2024.
24. Notice has been issued. Have you entered appearance in that?
No, notice might be issued.
No.
Might be have been issued. ସେମାନେ ଗୋଟେ ଗ୍ରାଉଣ୍ଡ ଦେଇଛନ୍ତି ଯେ appeal ପେଣ୍ଡିଂ ଅଛି, ତେଣୁ ଆମେ ଇ କରିପାରିବୁନି. appeal position ଟା କଣ ଆପଣ ଜାଣିବେ ନା? might have been issued. You just ascertain about that. We can take up this matter next week. Hello? This writ petition has been filed by the petitioner with a prayer for a direction to the opposite party for quashing the decision of the opposite party number 2 dated 17/8/2024, issued by letter number so and so under annexure 4 with a further direction to the opposite parties number 1 and 2 to disburse the apportioned amounts of compensation and other rehabilitation facilities covered under the law to the petitioner and opposite party number 10 in terms of the award under annexure 1. The Land Council for the petitioner submits that yes, the petitioners have received communication from such and such by Annexure 4 that the representation filed by them has been disposed of on 17/8/2024 by the competent authority, that is General Manager, East Valley area, in accordance with law. And he further drew the attention of this court that against the order passed by in civil suit number 38/2019 by the civil judge, Junior Division, Jharsuguda, RFA number 19 of 2024 has been filed in the, and it is pending in the court of District Judge Jharsuguda. District Judge Jharsuguda. However, when we put a query to the Land Council for the petitioner regarding the status of this case, submits that he will obtain the order sheet of the said case and file it on the next step. Put up this matter next week. Certificate copy. Put up the photo for
Item 46.
Yes.
May I please watch? The order of the tribunal has been assailed in this writ application matter, but the sole ground of assailing that we have made a specific averment in the counter, though the reversion order of 2001 has been challenged by the applicant before the tribunal of 2001, he assailed the same in 2018. We have
you just come to that order of the tribunal,
my lord.
That is Annexure 1.
Yes.
And please come to the prayer portion, which is mentioned in page number 2. That is running page is 19.
My lord. My lord. To issue direction to the respondent to extend the benefit of judgment reported on OLR 2006 Supplementary 1 page 449 and OGC number 11319 of 2001 dated 21/9/2010 Annexure A/6 or regularized and fixed the lien of applicant as was done in respect of similar placed persons by the office order 19/8/2016 of the DRM, and any other direction or order passed may be deemed fit and proper in the fact and circumstances of the case for which applicant shall ever prevail.
Now you come to the operative portion. Page number 24. Paragraph is 8.
My lord. In the instant case, also the applicant was given ad hoc promotion before 2019. Therefore, the decision of the Honorable Court, Odisha, High Court of Orissa quoted above are applicable to the fact and circumstances of the present case too. Accordingly, the applicant shall be reinstated with the same term and condition which were fixed by the respondent at the time of ad hoc promotion, and on the reinstatement, the applicant's service shall be treated as continuing on the ad hoc basis in the respective post held by him, and she shall be given consequential benefit accordingly. However, it shall be open for the respondent to consider the regular promotion of the applicant and other eligible persons in accordance with the existing guidelines. The entire exercise shall be completed within a period of 6 months from date of receipt of the copy of this order. Accordingly, my contention before the opposite party before the tribunal matter, though this order has been the revision order of 2011 that has been assailed in 2018 by showing the Honorable Court's order that passed in 2006 itself. Even if the order has been passed by this Honorable Court in 2006, applicant is not approached the tribunal to get the benefit of that judgment. And that is the law has been settled by the Honorable Apex Court. It is a fence sitter. He cannot, one body cannot approach in the court at himself. That is the sole ground. I have also.
No, when the order was passed by this court?
2006, madam. You also may kindly see the para 6. The subject of termination of the more than one ad hoc promotion may be subject matter of challenge before the tribunal And thereafter, before the Honorable High Court of Odisha in very many cases, Honorable Court of Odisha, OGC number 5477 and 54949 of 2002, by the order 7/3/2006 had held. This order has been also reported in 2006 supplementary.
He approached the Central Administrative
in
Tribunal
2018.
2018. So he must have filed that MA for condoning the deed.
But that in that score, the record is not showing that manner. And why you'll also make kindly see.
That would be a total different order, na? MA order ta pass way that a separate dispute.
But my humble contention in this regard, my lord, you'll also make kindly see para 3 of the tribunal's order, my lord.
Your only sole contention is delay.
Delay, my lord. That you'll also make kindly see. That is the Supreme Court judgment, my lord. That has been categorized in similar cases. One person get the benefits, and the person who was supposed to be filed the original application after the SLP has been disposed of the summoned application, and court has held that in the that is the state of Uttar Pradesh and the and others versus A.K. Srivastava and others. The Honorable Apex Court has been specifically held. One is voting to see what happening in the court, the person who has been challenged the same, and subsequently after they get the result, he approached the court. That benefit should not be extended to the person, those who are approached.
So is it your case that somebody else has been appointed in that post?
It is not that.
How you are prejudiced? How you are saying that I am suffering loss because I have already paid to that employee? He has worked for me. Now I have to pay for this man.
My lord, the background of the case is that, man, 2 adjunct promotion has been given. Despite the notification of the railway board, that the only 1 adjunct promotion should be given. And that has been, the promotion has been given in 1991. And when it is come to the notice in 2001, they had reverted. And accordingly, subsequently, the persons who was aggrieved by that order of reversion, they approached the tribunal in 2001 itself. And that has been confirmed in 2006 by order passed by the Honorable Court in 2006 itself. And petitioner is not challenged that order or not accepted the same till 2018. And he is not be prejudiced because already 2-3 promotion has been given to the applicant in the present cadre. We are specifically offered in that case. You also may kindly see the observation of the Honorable Apex Court in Srivastava case, my lord. In the para 22, may I? In the Petition itself, my lord.
Yes.
Para 22, my lord, page 363, my lord. 363. The legal principle which emerged from the reading of the aforesaid judgment, cited both the applicant as well as the respondent, can be summed up as under. The normal rule is that when a particular set of employees is given a relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violate the Article 14 of the Constitution of India. This principle need to be applied in service matter more emphatically as the service jurisprudence involved by this court from time to time postulate that all similar situated persons should be treated similarly. Therefore, normal rule would be the merely because some other similar situated person did not approach the court earlier, they are not treated differently. Next paragraph. However, this principle is subject to well recognized exceptions. The exception that has been dealt with by the court in the form of latches and delays as well as accusations. Those persons who did not challenge the wrongful action in their cases and accused into the same and woke up after long delay only because of the reason that their counterpart who had approached the court earlier in time succeeded in their effort, then such employee cannot claim that the benefit of the judgment rendered in the case of similar situated persons be extended to them. They would be treated as a fence sitter, and laches and delays and or the accusations would be valid ground for dismissal their claim. And this appeal has been allowed by the file by the state of UP on dashboard 11. And it is the case, my lord, where in 2006, the persons who has challenged on 2001 itself, and that has been concluded in 2006, and he has not approached the court to take the benefit. In 2018 itself, she's come to the...
Yes, Govinda Rao, it is mentioned.
My lord?
That name of that person has been mentioned as S. Govinda Rao.
That is that same, para 7. Para 7, you lord.
Yes, yes. S. Govinda Rao and others like I.
Again.
Whether the petitioner was a party in that?
No.
Okay.
It is not the case, madam.
Yes.
My humble contention that the court tribunal has noted that our contention, but not giving a whisper regarding the delay and latches. You lord, see me kindly see para 3. The respondent in the impugn order, my lord. The respondent in their counter internally averted that the OA is barred by limitation and should be dismissed as the applicant is challenging the order dated 13/11/2001 by which he was reported. But you will also may kindly see in the operative part as well as the court has been giving finding at para 5 and onwards. Nothing has been discussed regarding the delay in latches, madam. We overlooking this judgment of the Honorable Apex Court, where it was specifically stipulated that the fence sitter should not be given the instant the benefit the person who has been vigilant and take the.
All right. This petition has been filed by Union of India and others challenging the order passed by the London Central Administrative Tribunal dated for them to 25/4/2024 in way numbers 1. In directing the opposite party, in directing that the opposite party shall be reinstated with the same terms and conditions which are fixed by the respondent at the time of ad hoc promotion, and on reinstatement, the services of the opposite party shall be treated as continuing on ad hoc basis in the respective courts held by him, and he shall be given consequential benefits accordingly. The Land Counsel for the petitioner submits that this court, in the case of S. Govinda Rao and others versus Union of India and others, reported in 2006 supplemental OLR 453. Held that the petitioners in that case shall be given shall be reinstated with same terms and condition which are fixed by the opposite party of that writ petition at the time of ad hoc promotion, with inter alia with other direction. The opposite party filed the original application bearing OA number
67
of 2018. for a direction to the respondent to extend the benefit of the judgment of the aforesaid judgment further. है ना? The petitioners filed their counter affidavit, and wherein it has been stated that the OA is barred by limitation and should be dismissed as the opposite party challenging the order dated 13/11/2001, by which he was reverted in 2018. However, the London Tribunal did not take into account the submission which was made on behalf of the petitioners and passed the impugned order. Land Counsel for the petitioner drew the attention of this court to the decision of the Honorable Supreme Court in case of so-and-so reported in so-and-so, wherein it has been held that even though the normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. But such principle is subject to well-recognized exceptions in the form of laches and delays as well as acquiescence. Those persons who did not challenge the wrongful actions in their case and acquiesced into the same and woke up after long delay only because of the reason that their counterparts who had approached the court earlier in time succeeded in their effort, then such employees cannot claim that the benefit of the judgment rendered in the case of similarly situated persons be extended to them. They would be treated as fence sitters, and laches and delays and oblique or the acquiescence would be a valid ground to dismiss their claim. Within the contention of the Land Council for the petitioner that in view of the gross laches on the part of the opposite party in approaching the London Central Administrative Tribunal after 17 years. 17 na kete 17 years. The writ petition, the original application should have been dismissed. However, the London Tribunal has committed illegality in entertaining the same and also passing the impugned order. Issue notice on the question of admission, indicating that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Put up this matter after yes.
No, IA is there, my lord.
IA issue notice for 2 years.
That may be state.
One set of process. Let him appear. Let us.
Yes.
IA issue. Yes.
Item 47.
Item 47, Your Lordship, I pray for an adjournment. Let it come next week.
Adjournment means to next week or a week after?
Next week. Your Lordship, next.
All right. Next week.
Obliged.
Item 48.
Please, Your Lordship. Here, my lord, the petitioner has filed this writ petition for a direction to the opposite party number 1, 2, and 3, my lord, for disbursement of the compensation amount, my lord.
Representation filed.
Representation by Annexure 2 is pending before the opposite party number 2, my lord.
Yes.
Taking into consideration my Annexure 1 judgment of the
Annexure 2, what you have written appears to be a civil case.
Yes, my lord.
77.
In claim commission, my lord, what has happened in as per the judgment of the CORAM case, my lord. So far, 14 villages are concerned, my lord. A claim commission was constituted, my lord. That is why, my lord. Claim
yes, the question which has been put to you.
Yes, my lord.
Annexure 2 टा ଗୋଟେ representation କଣ ଏଟା ତ ଗୋଟେ petition ଟେ file ହେଇଛି.
Yes, my lord. It's a petition. There is a case, my lord, registered.
So that case is already a civil case.
Yes, my lord.
77.
Yes, my lord.
তাহলে রিপ্রেজেন্টেশন কোন সে সিভিল কেসটা ডিসপোজ অফ আপন ডাইরেকশন মাগিবে না রিপ্রেজেন্টেশন কোন
Civil case.
that is a civil case
Yes, my lord.
which is subjudiced before the claims commission.
Yes, my lord.
And now you are aware that the claims commission is not functioning.
It functioning, my lord.
It is functioning.
It functioning.
কেবে সে ডিসপোজ অফ হয়ে গেলানি কি স্যার জজমেন্ট আসিলানি সুপ্রিম কোর্ট
সেটা
ପ୍ରାଇଭେଟ ଶୁଣୁଥିଲେ କ୍ଲେମ୍ସ କମିଶନ ର ଯୋଉ ଜଜମେଣ୍ଟ ଟା ତାଙ୍କର ଅଗଷ୍ଟ 31 ନା 30 ପରେ ଆଉ ଏକ୍ସଟେନସନ ହେଇନି ବର୍ତ୍ତମାନ କ୍ଲେମ୍ସ କମିଶନ ଫଙ୍କସନ କରୁନି ସୁପ୍ରିମ କୋର୍ଟ ରେ ଜଜମେଣ୍ଟ ରିଜର୍ଭ ଅଛି ମୁଣ୍ଡରେ ହାତ ଦେଲେ କଣ ହବ ଜଜମେଣ୍ଟ ବାହାରିବ ତା ଭିତରୁ ନା ତ ପ୍ଲିଜ ଟେକ୍ ଆପ୍ରୋପ୍ରିଏଟ ଇନଷ୍ଟ୍ରକ୍ସନ ଏଠି ବର୍ତ୍ତମାନ ଏଇଟା ଡିସ୍ପୋଜ ଅଫ ଆମେ ଡାଇରେକ୍ସନ ହିଁ ଦେଇପାରିବୁନି କାରଣ କ୍ଲେମ୍ସ କମିଶନ ଏକ୍ସଟେଣ୍ଡ ହବ କି ନ ହବ वी डू नॉट नो ବୁଝିପାରୁଛନ୍ତି ତ ଆପଣ ଗୋଟେ ଡାଇରେକ୍ସନ କହୁଛନ୍ତି ଯେ ସିଭିଲ କେସ୍ ଯୋଉଟା ପେଣ୍ଡିଂ ଅଛି ସେଟାକୁ ଡିସ୍ପୋଜ ଅଫ କରିବେ କ୍ଲେମ୍ସ କମିଶନ ସପୋଜ that is not extended then the matter has to come to this court for disposal, right? So how can we pass a direction to knowing fully well that that period has already expired and it is not functioning? We are just adjourning the matter, so take proper instruction of land council for the representation. Representation will decide. Yes.
Item 49.
Hey, please, my lord. My lord, petitioners, my lord. Petitioners are, my lord, grade 1 bench clerk and a grade 1 stenographer under the judgeship of the Khordha, my lord. Here, my lord, under Annexure 1, my lord, petitioners were appointed as a junior clerk. Petitioner number 1 was appointed as junior clerk by the order dated 30th July 2005, joined on 16/8/2005. Similarly, petitioner number 2 also appointed on 9th August 2005 and joined on 10th August 2005, when the old pension rule was in force, my lord. But pursuant to the decisions of this honorable court in the case of Anand Chandra Das, my lord, and others, may I pass on, my lord? Know that because on the date of appointment, my lord, and date of joining in August 2005, my lord, the old rule was in force, my lord. That was amended on 17/9/2005 with retrospective effect from 1/1/2005, prohibiting the persons those who were appointed during that period 1/1/5 to 79, they are not entitled to be under the old pension rule. So that was challenged before your lordships, and your lordship in Anand Chandra Das, who is the staff of this honorable court, my lord, your lordship held that this amendment will not applicable retrospectively. It is only applicable from 17/9, my lord. Based on that, and that was upheld by the honorable apex court, my lord. Based on that, my lord, a general order was passed under Annexure 3 by the Law Department OP number 1, asking all the district judges to submit the employees those were appointed during the period 1/5/2005 to 17/9/2005. So under Annexure 4, my lord, page 19, this is the list which was submitted by their district judge for the, my lord. And my name is at serial number 1 and serial number 4, my lord. Where the date of appointment joining is 10/8/2005 and 16/8/2005. Then, my lord, we are asked to submit the undertaking that we will continue under the old pension rule and old GPF rule. And we also submitted our undertakings, and that was forwarded to the Law Department under Annexure 5. My lord, there under Annexure 6 also, my lord. Annexure 6 is, my name is there also. What happened, my lord? They kept the matter pending, and one Ramakant Das and Sitaram Mahapatra approached before your lordships in WPC number 688/1 of 24, where your lordships directed to consider his case. I'm passing on. Since the matter has already been settled by this honorable court and upheld by this apex court, my lord, their cases coming under the purview of that judgment, and their cases shall be considered, and the matter is pending for the Law Department. Accordingly, my lord, allowed only to Ramakant Das pursuant to your lordship's order, my lord, they implemented. So far as we both, even though our name was sponsored, they have not passed any of.
Now, when did you join?
I joined on 16/8/2005, August 2005, and the other is.
So why they have not taken?
They kept pending, my lord. I can say, my lord, by pick and choose method, they are allowing, and so I pray, my lord, your lordship.
Right. Instruction, Mr.
My lord, may I pray, my lord? Your lordship may direct, since the matter is pending before the opposite party number 1 and 3, to take a decision as your lordship directed in other case.
Take instruction. Why? Let us see. Why there is a discrimination? We'll see.
The
But now Annexure 7 doesn't relate to the petition.
Annexure? No, that has been granted in favor of one from that list.
Only one. That is what he is saying.
list ru na ta देखुनांती जो
Pick and choose he.
Annexure 5 रे ना गुड़ा जाइथिला तो यांको ना find place होची 1 and 4 रे. Right.
Might be this is an individual order, my lord. Okay,
This is based on the
taken out.
If there is reason, it's all right.
This is based on the direction of your lordships in the independent.
Land Council, this petitioners have approached this court with so and so prayer. Land Council for the petitioner submits that the case of the petitioner is squarely covered by the ratio laid down by the
Ananda Das versus State Commission.
Reported also, which has also been confirmed by the Honorable Supreme Court. And on the basis of such judgment, the Law Department sought for data pertaining to the appointment of all the employees
between during
the period from 1/1/2005 to 17/9/2005 to the all the district judges, and accordingly the data so far as the petitioners are concerned was submitted by the London district judge, which would indicate that the date of appointment of the petitioner number 1, Susmita Sarangi, is 10/8. Susmita Sarangi is 16/8/2005, and that of petitioner number 2, Santilata Patnaik, is 10/8/2005, and the government had adopted pick and choose method and only granted benefit by the Annexure 7 in favor of one Ramakanta Das.
Joined on 16/8/2000.
Who was joined on 16/8/2005. But no order has been passed in respect of the petitioners. Land Council for the state seeks some time to obtain instruction in this matter. So issue notice on the question of permission, so and so. Extra copy to be served. You accept the notice of all the opposite parties. Accept the notice of matter to be listed 4 weeks after. Counter if any filing in that.
May I pray, my lord? Date may other
4 weeks पर ऐसे ये बाकी जैसी और है ना काली supplementary ऐसे वो मैंने
Weekly list, item number 1.
Yes.
Copy not served in this case.
Part admit call for the trial court record. Interim applications for bail and stay realization of fine to be considered after receipt of the trial court. Learned counsel for the appellant shall supply the deposition copies of all the witnesses to the land counsel for the state in the meantime.
Item 2.
Item 2, Miller, he has filed an IA 1121 of 21 Miller for his mother's element.
Oh, you see. Dispose of Padwas is a fresh IA number 1121 of 2021. This is an application for interim bail on the ground of ailment of the mother of the petitioner. None appears. In view of the passage of time, in the meantime, this interim application is disposed of. Yes.
Item 3. Item 4.
May I please?
Use it that. সেটা ব্যবহার করুন তো।
My lord,
ওয়ার্কফ্রমটাও ব্যবহার করুন। সবগুলো পিস করে দিন।
A report was sought for from the police.
I have already sent the confirmation letter not received. Let it come next week, Miller.
Please say 3 to V.
Yes, Miller.
Okay. Land counsel for the state submits that so after receiving the extra copy of the appeal memo along with the interim application from the same as the Constable Police receive the confirmation later and the matter may be taken up next week. This is matter 28th October 2024.
okay.
Item 5.
Is your lordship, my lords. Lordship may kindly have a glance to the last order, that is order dated 1/10/2024, wherein upon surrendering the petitioner has applied for a fresh bail, wherein your lordship was pleased to call for the instructions whether there has been any kind of violation while on interim bail for 1 month.
Yes, Mr.
Let it come in Wednesday, my lord. I have telephoned him and instructed as sought for me.
Witness to a weekly
Yeah,
weekly.
remand, yes, Miller.
weekly তো ଅଛି
ওইটা আজই গোটে দিন পাইলি স্টেজ
এইটা
উইকলি নেক্সট উইক করবে লিখি দেবে এই সাবমিট জাস্ট he may be given some time further time to obtain instruction as per the order dated so on. Matter will commence on 28th October. Yes.
Item 6.
There are 3 appeal in the item 6, my lord. The last item. CRLA 306, my lord, of 2019.
IA number 2341.
IA 2341, my lord.
Yes. I number 2341 of 2024. This is an application for bail for appellant number 2, Vishnu Prasad Pradhan, my lord. Here, my lord, one of the co-appellant has already been granted bail by this honorable court, and the present appellant is in custody since 2/10/2015. 8 years, 11 months, at some days, near about 9 years. If Lordship kindly see the evidence of Schedule 1 is the victim. This paragraph number 6 of that order in which we granted bail to the appellant number 1.
Yes.
The relevant consideration is that from the evidence of the victim, she has neither named the petitioner Loknath Boi as an accused, nor has identified him in court during trial, and no other witness has stated anything against the petitioner. So against that man. So
yes, that's why I'm making submission. You will also have a glance to evidence of Schedule 1, Para 2.
So, Mr. Have you got that evidence of
Yes,
that victim?
yes.
And have you got the reasoning which has been mentioned in that?
Not named.
Connected literally.
Out JCRL 71 ସେଇଥିରେ
ଆସିଛି ଆପଣଙ୍କର
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ
ଆରେ ସେଇଦିନ ଦେବେ ଆପଣ ଏକାଠି ଆସିବ।
Item 7.
So here surrender certificate not produced. Who is appearing in this case, Mr. Tripathi? Item 7 Miller. କେତେ ଦିନ ପାଇଁ ଯାଇଥିଲେ ବେଲ୍? 3 ମାସ ପାଇଁ। BRT ପାର୍ଟି। ଆଚ୍ଛା ଲେଖନ୍ତୁ non appeals for the appellant. The appellant was granted interim bail for a period of 3 months in IA number 895 of 2019 by order dated 9/7/2024, and the Land and Council for the appellant was asked to produce the surrender certificate. Let the registry obtain instruction from the Land and Trial Court whether the petitioner has availed the interim bail granted on 9/7/2024 or not, and if so, whether he has surrendered at right time or not. For such purpose, file be placed before the Register Judicial, and Register Judicial will send email to the Land and Trial Court. Report be placed. Matter of what is of the foreign ASU. Yes. Report. Yeah.
Item 8.
May I please?
Yes.
Interim bail period expire on 8/11.
8/11. Land and Council for the appellant submits. Sole appellant.
My lord. So
That the interim bail period is supposed to expire on 9th of November. 8/11/2024. Put up this matter in the week commencing from 18th November 2024. Land Council for the appellant shall produce the surrender certificate.
Item 9.
may I please, your lordships. This is conviction under 302 and fine of rupees 10,000, lordships.
What is the delay?
Delay
508 days.
Lordships.
Live conviction.
Live conviction throughout he is in the custody from 18/6/2017.
So live conviction, we are condoning IA number so and so. This is an application for condonation of delay. The staff reporter has pointed out that there is delay of 508 days in filing this criminal appeal. Since the appellant has been sentenced to life imprisonment after hearing the Land and Council for both the parties, going through the grounds taken, we are inclined to condone the delay. Accordingly, delay is condoned. Hard admit call for the trial court report. Interim applications for bail and stay realization of fine to be considered after receipt of the trial court report. Deposition copies to be supplied to the Land and Council.
For 3 months he needed because he is in the custody from 18/6 to
आसु कागज पत्र आसु admission hela ji. Yes, next.
Item 10.
এটা ডিলে কন্ডন করে দেবে জেল ক্রিমিনাল আপিল एडमिट करी सर जहां कहले दे दे
कॉपी में भी
कॉपी येटा दे दियंतु जे जजमेंट कॉपीटा आउ से पिटिशन तो उटा आस्थियो हला संग दे दे स्टेट को दे दे Item 3. Oh, it is order. Yes.
For this case also 302, 304B, 498, 34 IPC. Here the petition is the appellant is
And item 16.
We'll take up the item number 3, say orders matter. After we'll do. Yes. What is the period of detention?
Detention is that is
he was in custody 11 to 12 months. 14 to 12 months. 14/2/2012 से
How
custody.
many appellants are there?
Appellant one.
One appellant.
One appellant.
3 persons face trial.
Right. Yes. Two have been acquitted.
Two have been
Acquitted. Yes. On the ground of 498 is not met to the doubt.
So you are the husband.
Yes, husband.
Okay. So what is the date of custody you said?
That is 14 to 2012.
14 to 2012.
12.
So have you been released earlier on bail?
No.
Never released?
No.
এটা ভালো না, হাইকোর্টে কোটা ভালো। उससे कौन पुलिस यूनिवर्सिटी आर्मी ना जाए कौन केस कौन
Allegation that the appellant killed his wife
Marriage
marriage
within 3 years.
marriage was held in 2009 as it appears.
Yes.
Asada 2009 লেখা আছে paragraph 2 রে।
Yes.
Our occurrence took place
11/2/12.
11/2/2012.
The cause of death is
As conduct that they killed by Koturi.
eyewitness.
No, but it's a circumstantial evidence based on circumstantial evidence.
And confessional statement under 313 million. Yes.
Homicidal death is the death of Shah West. Got injury on the right side neck, got injury on the right side front. Excessive hemorrhage to the large vessel.
ଗୋଟେ injured ବି ଅଛି injured ବି ଗୋଟେ ଅଛି କାହାର ଇଏଟା deceased ନା କଣ
This is not Kondhei.
ଆଉ ରାଜକିଶୋର ସ୍ୱାଇଁ କିଏ
Rajkishore is the father-in-law. No, sorry. One of the son, one of the brother of the
Yes.
Sir, item 22. Can it be taken out because bail, because more than 15 years is in custody. 15 years, 4 months. 27/6/2009.
It is listed in hearing list.
22 surrender certificate.
Let's
not-
surrender. But I
Hearing.
don't have the surrender certificate, or he has surrendered.
No, prisoner's petition at flag X মানে কোন? To appoint আচ্ছা ସେ ଆପଣଙ୍କୁ ଏନଗେଜ କରିବା ପାଇଁ ଦେଇଛି। ଠିକ ଅଛି ଆପଣ ଭି ନାମା ଫାଇଲ କରିଛନ୍ତି ମଧ୍ୟ। ଆଚ୍ଛା ଏଇଟା ଏଇ ଅର୍ଡରଟା ଲେଖିଛନ୍ତି 22 ନମ୍ବରରେ prisoners petition at flag X has been received wherein request has been made to engage Mr. Niranjan Panda as his advocate. Mr. Panda has already filed a V nama which is accepted. The name of the other counsel ଆପଣ ଖାଲି ନା ଅଛି ନା ଆଉ କାହା ନା ଅଛି?
No, only
the name of Mr. Niranjan Panda, the name of the other land counsel shall not be reflected in the cause list. कौन चाହୁଛନ୍ତି ଆଉ?
only interim bail for some.
application କାଇଁ? और मौखिक दिया हो ना को?
Hearing list আছে, hearing charge
हाँ कर दो ना कि hearing if you are ready. पेपर बुक नहीं चाहिए?
No, I have not.
नौना जी की मना कर दियो। चार्टा सेट पेपर बुक is paper book दे दो। Let a copy of the paper book be handed over to the land and counsel for the appellant to prepare the case matter to be listed next week. दे दो तो हम copy। एक नहीं जान पेपर बुक का नहीं जान।
Sir.
Yes. क्या अच्छा नहीं कौन? Item number
16 minor.
16.
16.
Yes.
Yeah. On the last occasion, your lordship was ascertained whether he is in the jail or not. But my friend has told that he has already
The
been
report was called
released.
for by this honorable.
Yes.
कौन आसिला जी? With due respect to son, JCR लेता?
ये जैसे 17/2008.
I would like to submit a report regarding the premature release of so and so. Ammonite in compliance the order dated so and so. Call for a report from this unit. My letter reported the conviction has been released. One has been received. Ammonite and bonus have been released prematurely. Dispose of for the Peru the report of the Land Fast Traditional Session Judge Baripada dated 16/9/2020, wherein it has been mentioned that the senior superintendent circle jail by letter number Swansea order has reported that the appellants Ammonite and Bono alias Santosh Naik have been released prematurely from jail on 31/5/2018 by Government of Orissa Law Department order number so and so. In view of such a
No, item 18 appointment.
The Prem Kumar Patna. I would have gone. Put in this year ready to